Services Bill. When we were considering the bill last night, we were on Part 5. This is debate on clauses 215 to 343, amendments to other legislation, and Schedules 5 to 11. The question is again that Part 5 stand part. The Honourable Dr. Deborah Russell.
Mr Chair, as at 9:55 p.m. yesterday evening, the Minister dropped another amendment paper on the table, which and we thought at the time, well, that's pretty unusual, having an amendment paper dropped. Not exactly at the 11th hour. It was the it was the 10th hour by then, I suppose. We might call it that. Who knows? And so we thought, well, what is going to be in this amendment paper? We'd gotten word that it was going to happen. And we now have it in front of us. Honourable Simon Watson Committee to move the following amendments. Clause 273 3A and Clause 273 bracket 3A close bracket new subsection 2EA replace 2EA page 242 with 2EAAA, and in Clause 347.3 to delete Clause 347.3 on page 283. So not a particularly exciting amendment, but given that it was dropped at the very last minute, I wonder if the Minister and the Chair could explain why we needed to have this particular amendment paper dropped on the table at 9:55 p.m. As we were debating this bill. It seems quite an extraordinary thing to do at this stage of proceedings.
Mr Chair.
The Honourable Scott Simpson.
Well, far be it from me, Mr Chair, to cast doubt upon the role of the Minister to put the amendment paper in at that hour. But clarity and certainty is important, and that's what this amendment paper seeks to achieve. And I'm sure the member will understand the necessity for those matters.
Chair. Mr Chair.
Tangi Utakiri.
Thank you, Mr Chair, and I thank the Minister for his brief clarity in that regard. What I find really interesting is, you know, at a moment when government members, the only contributions they were seeking as part of committee stage were to seek closures, we're seeking closures at the same time that this amendment paper was basically landed on the table. So that's a new one for transparency as part of process, isn't it? That's a new one for transparency as part of process, to land an amendment paper that has been tabled at 5 to 10. And I think actually the committee rose at about 4 minutes to 10 or thereabouts. Well, this is about the bill, because it means actually that we didn't know what this was about, at the same time potentially that we would have been voting on something that was actually not there. So that is certainly a new one for transparency. But I do thank the member, the Minister, for providing that clarity there. Now, Mr Chair, there is, however, an amendment paper in my name that was lodged back in July, and what that does is it provides an opportunity to amend Schedule 5, and so we are looking at Schedule 5 as part of this particular Part 5 of the bill. And so my question to the Minister is, well, firstly, whether he intends to throw his support behind my amendment paper, and for the benefit of the committee, this basically seeks to initiate some date changes. It is one date change, but it does nonetheless relate through the remainder of the schedule, and it's specifically related to Clause 29 when it comes to the new Part 5, which would be inserted into Schedule 1AA of the Commerce Act of 1986. And the rationale for promoting this change, basically replacing the date from 1 July 2026 to 1 July 2027, is to effectively give councils more time. Because what we are seeing clearly is a huge number of entities that have been identified in these water services delivery plans that are expected to be, with the Minister in the first week of September. It's not that far away. And the numbers of individual entities far surpass the expectations of the government, which is really causing them a bit of grief. So I'm happy to help them out and just give them a little bit more time to perhaps delay the implementation of this so that they can just think things through a little bit. So my question to the Minister is, amendment paper number 342, Minister, seeks to amend Schedule 5, effectively delaying the implementation of this because clearly what has been proposed by the government is not working. It is making things worse, and that's before it's actually even got underway. So, Minister, please indulge us in terms of your support for the amendment paper.
Mr. Chair.
Honourable Minister.
The short answer to the member's question is no. And the irony of that member, a member of his party, trying to talk about transparency on this day of all days is not lost on the Committee of the Whole.
Lard Farm.
Thank you, Mr. Chair. I would like to look specifically on page 247, and this is clause 269. And this is about the proposed wastewater and stormwater environmental performance standards. Now, this was an area that we started to touch on just at the very end of last night. In fact, I was in the middle of talking about this when the House had to rise. So I would really like to return here because I was only partway through my questions for the Minister. And just a point of order on that, Mr. Chair, are there questions already noted from last night from that aspect, or do I need to revisit any of those to make sure they're answered this morning?
You'd probably be safer, and the Chair will ensure you get the time to revisit, given that there is actually a new Minister in the Chair, will probably be the best way to go.
Excellent. Thank you so much for clarifying that. So the first aspect that I'm really keen to hear from the Minister about is on clause 2 of 58JA within that clause 269. And really this is about these set standards that are actually proposed outside of this legislation, but which are given effect to in this Schedule 5, Subpart 7. And the setting of these standards are such that my understanding, but I'd like clarity from the Minister, is whether they are respective or irrespective on the current state of the receiving environment. Now, the justification with these standards is that they are in some way tailored in that there are different categories of essentially receiving environments, whether that be high flow areas, so more like in our oceans or rivers, or low mixing environments like estuaries and perhaps lower flow rivers. Now, it's been unclear in our deliberations on this as part of the Select Committee process how much impact the current state of the receiving environment actually has on those standards. And so I'm really keen on hearing about that. And what I'm proposing as part of my amendment paper is actually to have this subsection apply only where the rule is less stringent than the wastewater environmental performance standard or the stormwater environmental performance standard. So that would basically have the effect of having those standards proposed and given effect to by this legislation only prevail where the rule is actually less stringent than the standards. And the example that I gave with addressing that came from Environment Canterbury when they talked about in their submission about the Christchurch wastewater discharge for the city and how these standards basically take that many, many times greater than what is currently permitted. And we heard from not just Environment Canterbury, but across local government, concern about this and concern about the water quality of the receiving environments, be that the rivers or the beaches. Now, the other aspect that I'm really interested in with these wastewater and stormwater standards is we heard from officials during the Select Committee process that they were based on international best practice. And I'd really like to hear what some examples are of those standards and how, whether those situations or environments, how they actually relate to New Zealand circumstances. Because the ecology we know of different environments is absolutely critical to whether these are actually having a serious adverse environmental effect or a lesser one. And so I'm really interested in hearing about that. The other aspect that I would like to get direction on from the Minister is further in this section, again 269, where, and this is section 3 of that section, and it talks about where there is any conflict or duplication between a wastewater environmental performance standard or a stormwater environmental performance standard, and the documents listed in subsection 4 that basically the wastewater and stormwater standards would prevail. Mr. Chair.
Large farm.
Thank you, Mr. Chair. Now, the documents listed in subsection 4 are really meaty, serious documents. These are national policy statements, New Zealand Coastal Policy Statement, a national environmental standard, and then we've got our regional policy statements, regional plan and district plan. Now, these documents are really the heart of environmental protections when it comes to a local level. So I'm interested in what the justification is from the Minister to actually override these democratic processes that have been undertaken by communities with councils to set rules, standards and limits, and then these proposed wastewater and stormwater standards are coming in over the top of that. And I would like to hear whether the Minister would consider simply replacing the words "the environmental performance standard prevails" instead with a document listed in subsection 4 prevails. And all this would mean is that where these standards have been made more stringent than the ones currently proposed, that they can remain. And this is particularly important because we know that we've got about 60% of our wastewater consents for our wastewater treatment plants coming up for renewal in the next decade, and 20% of those are already operating on expired consents. So these new water service entities are going to be making absolutely critical investment decisions about what level of treatment they'll be putting in place, and it would be fantastic if within those decision makings they could actually uphold where the community will has got to with their regional plans, with their district plans, and even things like the New Zealand Coastal Policy Statement and National Environmental Standards, which we know contain really serious bottom lines that would help keep our communities and our environment safer than if we were just making these standards much more lax, which we've heard again from councils is the effect of these changes. Thank you.
The Honourable Minister.
Thank you, Mr. Chair. The member makes cogent observations about the historic inconsistency of environmental water standards across regions. Now, some of the matters that she raises relate to inconsistency, different standards, different rules and regulations in different regions. And so the current receiving environment suffers from that inconsistent approach that has occurred over time, over years. And many of the consents, for instance, are expired and they include some unconsented wastewater discharges as well. So the proposed new standards in clause 269 will help fix that problem by prioritising clear requirements. That's pivotal and fundamental to this new proposed legislation. And so, yes, standards do vary from region to region in terms of the receiving environments. So the consenting authority cannot impose requirements more or less stringent than the standards, but the consent authorities will still have to consider the impact on receiving environment as part of the usual resource consent decision making. I would just make the point in relation to the issues that the member raises that it's been widely recognised, I think, across the House and by this committee that the current RMA system is not leading to good freshwater outcomes. And so I think there's general acknowledgement and understanding of that. So 20%, I'm told, of existing water treatment plants are currently operating on expired resource consents. The longest has been expired for 24 years. So there is some historic tidying up that needs to be achieved. And I'm confident and very optimistic that the passage of this legislation will aid and assist that in a way that hasn't previously been the case, and it has been the cause of significant frustration, not only to citizens, but also to the regulatory councils, but also in terms of the quality of water in various regions from receiving environments.
Chair.
Rachel Brooking.
Thank you, Mr. Chair. I raised a similar points, but in not as much detail as my colleague Leanne Farm last night. And the Minister gave me a short answer, but it didn't address my question, and it's still relevant. And I thank the Minister and the Chair now for answering some of those questions about about some of the problems with the Resource Management Act, which of course the last government repealed. And replaced with legislation that this government has in turn repealed. So the Minister's talked about an inconsistent approach to water standards, and I'm in no disagreement there. But what I'm interested in is that these standards are imported from different legislation into the RMA, into the Resource Management Act. That is what this part of Part 5 is doing. It's importing something from wastewater legislation into the Resource Management Act. And my question last night that still hasn't been answered was, what tests do those standards go through before they become standards that are then imported into the Resource Management Act? And are those tests subject to the considerations that the Resource Management Act does in terms of Part 2 of that Act and sustainable management, which is in the purpose in Section 5 of the Resource Management Act? And that question remains unanswered. And we heard there some, in the last contribution, some concern that some of these standards will be being created at an international level. And how do we know that these international standards will be appropriate for New Zealand-specific ecology? And that has not been answered when the Minister talks about an inconsistent approach of the RMA. That's across regions, but not across different countries. So what comfort can he give us that these standards will be as rigorous as they would have been if they had been made under the Resource Management Act, noting that he says, well, some of these wastewater treatment plants have been unconsented for over 20 years, which is of course egregious. But if they were consented under the Resource Management Act, then they would be subject to those Part 2 requirements and sustainable management. So where does sustainable management fit with these standards that this Local Government Water Services Bill is importing into the Resource Management Act in Part 5 in the bowels of the bill? If you could answer that, that'd be greatly appreciated.
Right, Leanne Farm.
Thank you, Mr. Chair. I want to continue on, jump ahead in the bill, still in Part 5, but this is later in the bill at page 286 and section 328. And why I'm jumping here is because I'd like clarification first from the Minister's response about the receiving environment. And I'm just checking if I heard the Minister correctly, saying that there actually is some form of regional variation that is put into these standards. And if so, how can that work, and what does that actually look like when you're actually not going to the detail of specific, like consent by consent levels, clearly, but is there like literally a regional formula? Because would that actually apply versus like the actual different ecosystems and different environments that these discharges are actually going into? So I'd like some clarity on that. This clause that I'm picking up on, though, is really about a proposal to amend the bill to state that consent authorities would have discretion over the activities controlled by wastewater environmental performance standards. And the same could go for the next section to the stormwater environmental performance standards as well. Now, why I'm interested in this is because these sections preclude public notification of applications for resource consents when it comes to these wastewater or stormwater environmental performance standards and the activities that they would allow. Now, if the government is saying, and they're going to be, saying these are a set form of standards and that they will not give any regard to regional plans and district plans where local people have actually made the rules, then surely it would warrant public notification so that local people actually get to input and have their say, and at least that being an option rather than completely precluding public notification. So my proposed amendment, which I'd appreciate the Minister considering, is to replace is precluded, and sorry, this is 3282 2A, C, 1 and 2, is precluded from giving limited notification of an application for a resource consent has discretion over whether to provide limited notification of an application for a resource consent or whether to provide public notification of an application for a resource consent. Again, it's simply giving the discretion as to whether they could do that. Particularly, this would allow not only the set standards which are being proposed to be put in place, but it would actually provide for some level of input from local people in response to the local environment. So I'd really like to hear the Minister's thoughts on that. Thank you.
Mr. Chair.
Dr. Lawrence Zunan.
Thank you, Mr. Chair. And also it's good to see Mr. Chair back in the House as well. Just following on from what the Minister has responded, which is around some of the amendments, and particularly the late amendment that we have mentioned, that was dropped at 9:55 p.m. last night, and I think there was a part of that we'll mention later on in part 6. Just hearing the Minister's response in terms of clarity and transparency, it is important, I think, on the basis of transparency, that the Minister considered what my colleague Lan Pham has proposed in her amendment in terms of the ability for there to be publicly notified, that the public is able to be notified of such changes. My question to the Minister is, in an earlier section in subpart 2 on amendments to Commerce Act 1986, and I'm looking at clause 225, new subpart 12 of part 4 inserted. And I want to specifically ask the Minister around 57AB, ordering council declaring water service. There are two questions that I have on this section. I think the first one is just a clarification of subpart 1A and B. Is what the minister is saying in that is that on the recommendation of the minister, the Governor General will be declaring when essentially one or more water services becomes declaring one or more service that involves water service, essentially when it's established, or one or more service not be a stormwater service, as in it no longer is, but it was before. Because the way that I read this particular section, it means that the Governor General is able to just make declaration on both sides. I feel like it's got this interesting, conundrum here, where a service is both a service or not a service unless a minister makes a declaration. So I just want to get clarification that A is involving when something becomes a service, and B involves a service that is existing service no longer being a service. So that's my first question for the minister in terms of clarification. I guess the second part is in terms of the recommendation of the minister, and the minister must be satisfied that the commission has made a recommendation. On the surface, it looks reasonable, but in the context of the fact that this sits under Commerce Act, can I just check, is what we're saying here is that the declaration of what is a water service and what isn't a water service is on the recommendation of the relevant minister of the Commerce Act, which is the minister himself, the Minister for Commerce and Consumer Affairs, and the commission is the Commerce Commission in that case. So is what we're seeing here that the secondary legislation of determining or declaring a water service is not done under local government, but done by the Commerce Minister and the Commerce Commission? That's my second question, if the Minister wouldn't mind clarifying. So those are my two questions. The clarification on 57AB1, and also just in general, for clarity that the Minister and the Commission here is Minister for Consumer and Customer Affairs, Commerce and Consumer Affairs, and Commerce Commission. Thank you.
Mr. Chair.
The Honourable Minister.
Responding to the member's question relating to the Minister of Commerce and Consumer Affairs, he can be assured of the diligence and proactive attention of the Minister in relation to that. I can give him that personal assurance. I want to just go back to the question that the Honourable Rachel Brooking asked about RMA, particularly because RMA has been a subject of enormous discussion, debate over decades in this chamber and outside. So look, the provisions of this piece of legislation are designed entirely to ensure that that the statutory purpose of this legislation is adhered to, and so the decisions we made in accordance with the statutory purpose and the empowering provisions in the Water Services Act. And I would just take the opportunity to remind the committee that the relevant purpose in providing for this piece of legislation is for the progressive improvement of quality of water services, and that is the nub of it, and usual RMA considerations will apply through the consenting process. Lan Farm asked some questions that relate to different receiving environments, and the point I would make in response to her line of questioning is that there are 7 kinds of receiving environmental processes provided for in discharge to water standards, and different regions will have, as I mentioned earlier, they will differ from one to another. So those different receiving environments will need to be ultimately aligned. That's part of the purpose of this legislation, but there are 7 kinds of receiving environments provided for in the legislation. I hope that assists the member in some way.
Mr. Chair.
Thank you, Mr. Chair. Keen to just do a quick call on the Minister's answer there. And he said that the provisions that are being imported into the RMA must meet the purpose of this bill, I think is what he said. This bill being the Local Government Water Services Bill, being different from the Water Services Act 2021, which is where these performance standards come from. And he then referred to the purpose of this bill, the Local Government Water Services Bill, being about the improvement of water services. Now, Mr. Chair, the improvement of water services is quite different from the improvement of water quality from the receiving environment. So if we're thinking about water services, we think about a treatment plant, a water treatment plant, and we want that water treatment plant to be improved. And presumably that does include some of the discharge, but my concern here is that the discharge that comes from that water treatment plant might not have to be subject to the same controls as a discharge coming from a treatment plant that was controlled under the other provisions in the RMA, such as a national environmental standard. A national environmental standard that has to be made in accordance with Part 2 of the Resource Management Act, and that it is the Resource Management Act Part 2 that has this sustainable management purpose to it. So if the Minister could come back to me on that the purpose he was referring to, and I see his officials looking at him, the purpose he was referring to was in the Local Government Water Services Bill, and how that purpose then relates to the purpose of the RMA. Does he understand or agree, or does he disagree for some reason with my point that improvement of water services is different from improvement of the water quality in the receiving environment? So in the coastal environment that a treatment plant is discharging, we're talking about sewage here, right? We're talking about sewage. The Minister was talking about sewage, so it might be going to the coastal environment, it might be going to land, it might be going into a river. What are the controls for that receiving environment, that river, that coastal environment? Are those controls based on sustainable management, or being the purpose of the Resource Management Act, or are they based on improving water services? So it's quite a simple question. Please give me some comfort that in fact, because it's coming under the Resource Management Act, it should definitely be going back to sustainable management as the purpose.
Mr. Chair.
Dr. Hamish Campbell.
I move that debate on this question now closed.
Mr. Chair.
Tangi Utikiri.
Thank you, Mr. Chair. And perhaps the Minister may want a bit of time to respond to my colleague, the Honourable Rachel Brookings' question. Simple one. Look, I just want to touch on a couple of things that haven't been referred to yet. This actually does relate to the amendments that are proposed to the Water Services Act. So when we come to clause 307A, which seeks to amend section 32 of the Act, this is about compliance, monitoring plans and the like from Te Mata Arawhai. When we look at subclause 6, there are 4 examples listed in relation to a drinking water supplier. And my question to the Minister is very simple, is there actually a requirement to list those? And why not just leave it as actually a drinking water supplier? Because it's referring to subsection 3, which is pretty clear, but maybe it's simply a catch-all and whether that's needed or not. I'll leave that with the Minister. The only other one I wanted to raise was clause 308C. This seeks to insert a new section 43A, and this is around management of risk when it comes to the provision or additional provisions for water service providers. And in particular in subclause 3, it does reference the use of contamination of water. Now, this is obviously something that is of particular concern and interest, and certainly, yes, the use of contaminated water, however that might be described, could be utilised in a way that is friendly to the receiving environment. But can the Minister provide some guarantees and assurances around what could be seen as the timely and effective public notification in terms of communication for this? What we have as part of the former parts and elsewhere are requirements around notification of notices, etc. This is about the public communication of warnings of circumstances where contamination or other sort of issues may arise.
Mr Chair.
Dr. Lawrence Zunan.
Thank you, Mr. Chair. I think while the Minister is getting some advice, I just want to touch on a few additional points here. And the first one is Section 269 in terms of new Section 58JA to 58JC. One of the things that I'm interested in, and again, just for the Minister's sake and also clarity, things that I'm looking for and have questions for the Minister, by and large refers to the new amendment that has been released post-select committee, which is amendment paper from the Minister, amendment paper 246. So in here, there's a new section 58JAA that's been introduced in terms of plan that may permit effects that wastewater or stormwater environment performance standards does not deal with. And I just wanted to check with the Minister on, in terms of the rationale for including that as part of the amendment paper, as part of the amendment around wastewater and stormwater environment performance standards, on why that part wasn't something that was considered previously, and what is this additional section is intending to do. And the same thing we're seeing here in later section, in section 273, section 104 amended, where a new section has been inserted into the A, when you're looking at in terms of wastewater environment performance standard and infrastructure design solution as well. So again, we're seeing these reasonably substantial sections that's been introduced as part of amendment paper 2346, but there's no commentary to this amendment paper. So it's really hard for us, not having any advice from the officials, to know what are some of the intentions behind this. And I just also want to remind the Minister, I appreciate the Minister's response in terms of confirming that my earlier question, that is indeed the Minister for Commerce and Consumer Affairs for some of those, but I think if the Minister wouldn't mind responding to my question around 57AB that I mentioned previously, around this interesting case of a Schrodinger's declaration, where water service is both a water service and not a water service potentially at the same time. So if the Minister wouldn't mind responding to that. So the question primarily is just, again, just to remind the Minister in case I'm jumping through too many sections, it's primarily section 269, 58JAA, and 273, the new section 1A and the new section 2DA. Thank you.
Mr. Chair.
The Honourable Minister.
Look, thank you, Mr. Chair. I want to go back to the issue that the Honourable Rachel Brooking raised, and I want to just restate the previous answer I gave, because I'm not sure that she quite grasped what I was on about. The issue really relates to decisions that are made in accordance with the statutory purposes and empowering provisions in the Water Services Act. Now, relevant purpose is providing for progressive improvement of quality of water services, and then usual RMA considerations will apply through the consent process. So what's important in terms of the standards is that those standards are focused on the impact or the receiving environment, and they're designed to achieve consistency across wastewater services. And we know that there is inconsistency at the moment. So the purpose is to provide some consistency. Now, consistency that is good for the environment and also design and provision for water service consistency as well. Now, what we do know is that across the country, controls will be similar, but they need to be consistent. And so that is an ongoing process. There isn't going to be a sort of a moment when it is all consistent from day one, but that is for want of a better term, a journey of consistent improvement over time. And I'm excited by that opportunity because I think that the member will share with me my concerns, our mutual concerns about the quality of the discharges being suitable for purpose and much better than they are in some parts of the country now. Tangi Utakeri asks a question about why list some drinking water suppliers, and I think that was in particular reference to 307A. And I'm advised that the provision limits application of information and related powers to limited categories of drinking water suppliers to ensure any burden is proportionate to the risks and the costs. So again, it's a balancing, proportional test, which I think under the circumstances is appropriate.
Rachel Brooking.
Thank you, Mr. Chair. Just in answer to the Minister's answer to me. No, it's not an answer. I'm not giving the answers. I'm asking the question. And that question is, so the Minister there was clear in saying the purpose is the purpose of the Water Services Act, which is an act already in place, and that purpose is to improve the quality of water services. But then there'll be some resource management consenting issues as well. But that doesn't answer my question to the Minister, which is there anything then in the Water Services Act around what the quality of a water service is defined as, or in the provisions of the Act, which I don't have in front of me, that relate to improving the environment? So improving the environmental quality, so the quality of the receiving environment, be it the river, the coastal environment, whatever it is there any requirement to improve that quality rather than the quality of the water service? Can the Minister understand the distinction that I'm making here between a water service and the receiving environment? So it's just that very small point. Is there anything when in any of the requirements for these standards that will be imported into the RMA that requires the receiving environment, the river or the coast, to be improved?
Mr. Chair, the members asked the question 3 times now. I've given 2 answers. I'm not intending to give it a 3rd time, but I think that the previous answers I've given make it clear that there is a requirement for environmental improvement. That's the whole purpose of not only this piece of legislation, but a variety of other pieces of legislation. I want to turn to the question specifically that the member Lawrence Yunnan asked, which was in relation to when a water service is and is not a water service, clauses 57A-B. And I'd simply respond by saying that it allows flexibility given the developing nature of New Zealand's water services. So again, it's part of the ongoing development of the water services regime.
Carlos Chong.
I move that debate on this question now close.
The question is the debate on this question now closed. All those in favour say aye. To the contrary, no. The ayes have it. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour. 34 votes opposed. Grand Party of Aotearoa, New Zealand.
14 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed. The question is that the Minister's tabled amendment to AP number 346, amending clauses 2733A and 2996 be agreed to. All those in favour say aye. To the contrary, no. The ayes have it. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour. 34 votes opposed. Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
8 in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 54. The question is agreed. The question is that the Minister's amendment to Part 5, set out on AP number 346, as amended, be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
8 in favour.
Te Pāti Māori.
May I correct my vote? 14 votes opposed from Te Pāti Kakariki, 5 votes opposed from Māori Party. Sure.
The ayes are 68, the noes are 53. The question is agreed. I'll just ask the Green Party member, in the previous vote you cast 15, should that have been 14?
Yes, if possible, I would like to correct the vote to say 14 votes opposed from the Green Party.
Okay, we'll correct that. There's leave given to correct that party, that vote from the Green Party. Leave is given. Question is that Land Farms tabled amendment to clause 269, new section 58JA to replace subsection 2 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed. The question is that Land Farms tabled amendment to clause 269, new section 58JA3 be agreed to. All those in favour say aye. Aye. To the contrary, no. The noes have it. Clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
Leave it opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori. Te Pāti Māori.
5 votes in favour. 5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed. The question is that Land Farms tabled amendment to clause 328, new subsection 2AC of section 138 be agreed to. All those in favour say aye. To the contrary, no. The noes have it. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
Leave it opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed. The question is that Part 5, as amended, stand part. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
ACT, New Zealand.
Leave it in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed. Members, we now come to the debate on Part 6, which is debate on clauses 344 to 432, miscellaneous provisions, and Schedule 12. The question is that Part 6 stand part.
Mr Chair.
The Honourable Scott Simpson.
Well, as we begin debate on Part 6, Mr Chair, I thought it might be appropriate to just give a little bit of an overview of the part and what it contains. So it's made up of a number of very practical operational provisions to enable water service providers to effectively manage and protect their water service networks so services can be delivered to required standards. Part 6 provides water service providers with regulatory powers in relation to bylaws, compliance and enforcement mechanisms, and it includes offence provisions as well. It empowers councils to make, amend, revoke, review and enforce water services bylaws. A water organisation may propose a bylaw, undertake consultation on behalf of the council and have delegated responsibilities to administer or enforce bylaws while the council retains ultimate responsibility for bylaw making. So in addition, this part requires that the Minister of Local Government initiate a review of water services systems within 54 to 66 months of commencement.
Taki Utakiri.
Thank you, Mr Chair, and thank you to the Minister for running through that brief overview of this final part. I want to ask the Minister, I was hoping actually that as part of that overview he would have shared with the committee the rationale behind the amendment paper that was landed at 9:55 last night. 9:55 last night. To delete clause 3473. Now, it may appear, I guess, innocuous because it's just one-liner, but basically it seeks to delete an entire clause. And so the clause that it seeks to delete is under section 347, which is around the power that is given to make water services bylaws. And I hear some sort of comment there from the Honourable Rachel Brooking, and it's because the surprise, I think, that this has landed late in the piece. However, what this seeks to do is delete sub-clause 3, which identifies that before making a bylaw relating to the discharge of trade waste, a territorial authority must follow the process set out in a particular subsection of the Local Government Act of 2002 before things proceed further. So I had to refresh my mind as to what section 148 sub 2 through to 4 actually required. And so I was a very good Deputy Mayor, but I have to say I had to refresh my memory. So early in the morning around bylaws relating to trade wastes, and basically the crux of it is that the Minister is seeking to delete the ability to consult with the public over this issue. So what that subsection identifies is basically a 2-month window within which there needs to be some opportunity for a public notification period to exist, following engagement with the Minister of Health, who may identify some other entities or individuals that also need to be consulted with, before this trade waste bylaw is actually allowed to happen or come into effect. And so my question for the Minister is, why is he seeking to remove that time? And it may be because, it's contained elsewhere. Well, if that was the case, why did he wait till 5 minutes before the House rose last night, or the committee rose last night, before he needed to land this here? Is it somewhere else? No, it's not. I mean, the proposal was to initially delete it in B, but put it into the subsection proper. Now the Minister is seeking to delete it in its entirety. So I've got some real concerns, not only around the sloppiness within which this was landed so late in the piece, because there are we hear some groans from the other side there, but there's nothing that has been identified by the Minister while the committee has been dealing with this to identify this as a change. So given that we have had quite some time, and the Minister's own amendment papers, I think, were publicly released back on the 29th of July. So why is there the requirement for the sloppiness and also the element of haste to remove the ability for the public to be consulted around this? So that's why. And also, actually, the Minister didn't actually identify anything in the House last night to say. So this is rather sneaky behaviour.
Oh, Mr. Chair. The Honourable Minister.
Mr. Chair, this is the second time this morning that member has drawn attention to issues that relate more to matters internally within his party than anything to do with this legislation. But I don't want to cast any aspersions on his previous life as the Deputy Mayor of Palmerston North. But there is a simple reason for the amendment paper, and I want to just make it clear to the member and also to members of this committee that clause 347 bracket 3 is being deleted because it refers to section 148 of the Local Government Act of 2002, which is actually being repealed by Schedule 12. Now, the role of the Minister of Health is transferred to the Water Services Authority as the Drinking Water Quality Regulator, and section 148, which requires bylaws to be sent to the Minister of Health, is therefore not required. So that's an explanation of the amendment paper that was produced last night.
Rachel Brooking.
Oh, thank you, Mr. Chair. And good to have that explanation from the Minister. And of course, it would be a much simpler process if when ministers put little amendments on the table at 9:55 at night that they tell the House about what they're doing and even why they're doing it. Imagine that. But I am also interested in this clause 347, powers to make water services bylaws, because of course bylaws are very interesting things. They are something whereby a council can act as a rule maker. So it is good that we have 347 that sets out where these bylaws can be made. That's always useful to have these specific provisions in legislation, so people know that they have councils have the knowledge that they have the authority to make such a bylaw, rather than having to work out whether or not they can or not. So, but I'm interested in D, 1D, which is managing a stormwater network, including bylaws to support a water service provider's stormwater network risk management plan. And we did have some discussion about this in an earlier part of the bill.
Have you got the page for that?
Oh, I'm on page 282 of the
282
of the big amendment paper.
Okay,
Is what I'm looking at. Not the little amendment paper that was landed at 9:55 last night that we might not have noticed. Now, so the discussion that we had, if the ministers found it, I'm looking at 347D. The government members are saying that it was that because we're in extended sitting that we're still on Wednesday. Well, in the House we are. That's nice to say that in the House that we are still on Wednesday. That does not detract from the fact that it was at 9:55 p.m. on Wednesday night that a very small amendment paper was put on the table and nothing was said about it until the next session, which we are in now, when we had to raise it as a topic, which seems a very bad way to make laws. And I don't disagree with what the minister said when he did actually raise it, but he didn't actively raise it, and that is the problem. But it's not actually what I was talking about, which is 347D on page 282. And this is whereby a council will be able to make a bylaw at 170 that requires private property owners to, well, I never got an answer to this question, but I think it means that they have to actively undertake proactive activities to stop hazards, to clean up waterways, to do things before a water event happens. And I asked in that part as well whether or not there had been advice that the minister can share with the House about that ability for a council to impose these requirements, active requirements, onto private property owners, rather than the more orthodox approach of a bylaw which says don't go into these areas. So it's a don't do this, rather than you have to actively manage these things. So because it is a tricky legal issue, and it's one that I remember discussing in the last Parliament as well. And then my next point in relation to this bylaw making power is, of course, that it is for councils to make bylaws and not water organisations. So we see that at 348. So when a water service, the water services provider is a water organisation rather than a territorial authority, then that water organisation can propose a bylaw. But of course, some of these water organisations will have more than one council, one territorial authority. They might have two, for instance. So there is provision in this clause 348 for when there are multiple territorial authorities within that water organisation. And it says that, it basically says, well, the recommendation for a bylaw can be that both, or however many councils there are, should undertake the bylaw making process. But however, it says at clause 4, that does not apply if there is good reason for a water organisation not to make the same proposal to to each territorial authority. So my question, Mr. Chair, my question is, if the Minister can give some examples whereby it would not be appropriate for councils to have the same bylaw that the water organisation is requesting to do things like require private owners of property to clear debris or to not do certain things in different parts of an overflow path, or anything else to do with the bylaw. What sort of circumstances would the multiple councils that are involved in a water organisation want different bylaws? And surely the point of having this water organisation is that everybody is following the same rules. Thank you, Mr. Chair.
Mr. Chair, Honourable Scott Simpson.
Mr. Chair, just in relation to the specific question asked by the Honourable Rachel Brooking in reference to clause 347D, which relates to the managing of stormwater networks. Now, I wasn't in the chair during Part 3 debate, but I'm advised that that matter was answered clearly during Part 3 debate, and it provides that they can impose requirements on private landowners. So that answers the question the member was asking.
Dr. Ramzunan.
I want to focus my questions to the Minister on subpart 2 and beyond, mainly around compliance and enforcement. I want to start by asking the Minister a question on the newly introduced sections of 357 on infringement offences, whereby 2 additional sections relevant to the Criminal Procedures Act 2011 has been applied here. And I want to check with the Minister that in the context of infringement notices, and particularly when it comes to fines, 2A and 2B suggest that essentially a defendant who's convicted of an offence can be done by a bylaw, but that particular, I'm assuming the interpretation is that 2B doesn't have to be applied if the offence is happening in another jurisdiction from which there is no similar or comparable bylaw. But I want to check this in terms of, or testing this particular section in the broader scheme of when we are looking at the collection of fines and the collection of, in the case of infringement offences, would that then apply to other areas whereby the enforcement of such collection of fines can only be limited to that particular bylaw jurisdiction, or can it be expanded more broadly nationally? So the reason I suggest this, and I want to get clarification from the Minister, is, let's say, for example, that there's currently a trial going on where a bailiff is able to scan a person's vehicle and check if that particular person has a fine associated with that particular vehicle. However, if that vehicle is registered to a specific area and the fine is limited by a specific area's bylaw, would that mean that the bailiff has the jurisdiction in another area to impose or to apply that same level of, ability to fine or to compound a person's vehicle if it's not from the bylaw? I'm hoping that that makes some sort of sense. It makes sense in my head. It depends on the jurisdiction of bylaw. If it doesn't make sense, I suggest that the Minister respond to that rather than people from the other side who may not have had the same experience dealing with legislation or criminal matters, and I suggest that they go and do some learning. And I would like to move on to another part, and that's my first question, which is around the enforceability and jurisdiction of bylaw based on the new 2 areas of 2 and 2B in 357. I want to move on to 371, which is power to obtain information. And this is something that has came up in other legislations. I want to focus on the power of a compliance officer and its interaction with the privilege of self-incrimination. And I want to get clarification from the Minister that when we're looking at the Search and Surveillance Act and subsection 3 of 371, when we're looking at privilege and confidentiality, it applies to anything done in this section, but this section, nothing in this section limit other legislations as well. So what I'm just want to get perfectly clear, that within the power of a compliance officer in 371, that will still uphold the fundamental rule, as we see in Search and Surveillance Act, that people will not be put in a situation where they are self-incriminating. And this is going to be really important in terms of the power that is being granted to a compliance officer in 371 subsection 1. Again, this has been a long-going and well-known cases in New Zealand and also internationally that uses New Zealand, and particularly the obiter dictum in the famous Taylor and the Poultry Board case in the 1980s, that this something fundamentally challenges our Bill of Rights. So I want to just get a clarification from the Minister that that is, my interpretation is correct, that it's not going to get people to self-incriminate. Sorry.
Mr. Chair, I hesitated because I was just wanting to make a response, particularly in Lawrence Yunan's request for information regarding clause 357, the infringement offences. I'll come back to his second matter probably after the next contribution. But he asked whether it was what was in his head was being made clear to others, and it would be totally inappropriate for me to try and ascertain what was going on in his head. And I don't mean that in any negative way, but from my understanding, the point that he raised was really seeking some clarification about the extent to which those enforcement provisions would apply outside the jurisdiction of the bylaw creating entity. Is that my yeah? And I'm not even in the member's head, so that's probably a good thing. So I just want to make the point that the new clauses clarify that the infringement offences in the bylaw only applies in the district the bylaw is made in, and so that's to clarify, not make substantive change. It's just that 375 it just applies to section 375 of the Criminal Procedure Act of 2011 is the particular reference that I'm advised, that the infringement is not recorded as an offence but as an order to pay fines and costs. So 357 is limited to those water bylaws. It doesn't extend beyond the water bylaws. I hope that helps with the members' understanding.
It's a bit early in the morning for mind reading, but well done.
Yeah,
the Honourable Dr. Deborah Russell.
Thank you, Mr. Chair. Just to remind the House that the Minister in charge of this bill put an amendment paper on the table at the start of the committee stage. So we're flicking between the bill as reported from the Select Committee and the Minister's amendment paper. And the interesting thing about that is the things which are in the amendment paper which were not in the bill as reported from the Select Committee. So I want to go to clause 374 in the bill as reported from Select Committee. So it's on page 4 of I'm looking at on the bill as reported from Select Committee, and in particular I'm looking at clauses 5 and 6. Which says that 5 is that a compliance officer must not enter any land on which a marae or an urapa is situated, or that is a Māori reservation, except with consent of an owner. On page 310 of the bill as reported by the Select Committee. Clause 5 there. So that was 5, and 6 is a compliance officer must not enter any Māori land unless before entering the compliance officer has given reasonable notice in writing to the owner or owners of the land. So the first question a person might reasonably sort of say to themselves, well, what is meant by Māori land? And in the Select Committee version of the bill, Māori land has the same meaning as set out in Section 4 of the Te Ture Whenua Māori Act 1993. So that's what's going on in the original version of the bill. In the bill as sitting in the what has come through from the Minister, sitting in we've got the definition of Māori land, but then we've got a definition of Māori-owned land. Māori land, a Māori reservation, any land in which a marae or urupara is situated, and reserves and so on. That's fine. Flicking through to Clause 374 in the Minister's Amendment Paper, this is on page 295 of the Minister's Amendment Paper, we find that in Clause 6, so the compliance officer must not enter any Māori-owned land, so there's a little clarification sitting there, not just any Māori land. But then there's also a whole lot of sub-clauses added in 6 to specify exactly what land is intended. So it's A, the marae, if a marae is situated on the land, B, the trustees of the principal marae, of the hapu that is associated with the land, and so on. So what it's doing is specifying who must be contacted. I'm interested in that because it seems like there's a considerable amount of clarification or additional text added into Clause 6 of Subclause 6 of 374 in the Minister's Amendment Paper. What is the policy thinking behind that? Why was it there felt to be a need to add all those clarifications? If the law was not sufficiently clear before as to the proposed law as to who ought to be contacted, it seems very much like a belt and braces approach, but what confidence do we have that the braces there are actually doing the work or that they add to the law as written? So just if the Minister could clarify what the policy thinking was behind that.
Mr Chair. The short answer to the member's question is simply to provide clarity and certainty.
Honourable Rachel Brooker.
Thank you. Just a short contribution from me. And one, we're discussing that relates to the offence provisions and the enforcement provisions in this Part 6. And I haven't seen anything in relation to whereby a person breaches a bylaw and the water service has an opportunity the water services provider has an opportunity to turn off that property's water source. And I was wondering if there is any link into this part of the bill about that ability to turn off the water source for a breach of a bylaw, or if that is actually just quite separate and there's no link to this part of the bill. Thank you.
Dr. Lawrence Unan.
Thank you, Mr. Chair. And I thank the Minister for knowing exactly what I was asking. I appreciate that. I do appreciate that. I have two additional questions. I'm looking at subpart 3, offences, and I will refer to a few of the clauses, but just for brevity, the two questions I have for the Minister is sort of more thematic. So, for example, the first question is around, let's say, Clause 394, and we're seeing similar terminology being used in, let's say, 396 and 403, because it simply is a repetition between water supply network, wastewater network, and stormwater network, but the wording is the same, and I want to check in terms of the wording. My understanding here is in terms of 394 et al. And other sections, subsection 1A implies the actus reus of a criminal offence, and B is the mens rea component of a criminal offence, and subsection 2 is the consequence of those. I want to check with the Minister, because A, in terms of actus reus, is fairly straightforward, but B conflates two very different elements of the mens rea around intention three very different areas of mens rea: intention, knowledge, and recklessness. Can I just check that while they're all being put under one subsection, which is subsection B, those three different degrees of mens rea will be considered when liable or conviction is being determined? So as in that when we're looking at, for an individual, a term of imprisonment not exceeding 2 years, or a fine not exceeding 75,000, or for a body corrupt, a fine not exceeding 1.5 million, that the degree of that will be determined on, that will still be determined on varying degrees of the mens rea in accordance to 1B, as opposed to intention, knowledge, and recklessness being combined into one totality, so to speak. So that's my first question, is around mens rea. And again, that's clause 394, 3961, we see in 3941B, 3961B, 4031B. My second question is around clause 395, 397, and 404, because it all includes the term negligently. Now, negligently, in the sense of criminal law, forms the fourth part of mens rea, and it does have a certain level of connection in terms of liability. And in general, when we're looking at negligence, we're looking at something that is either strict liability or limited liability. But I want to check with the minister here that in clause 3952A, 3972A, and 404.2A, it specifies an individual to a fine not exceeding $50,000, actually $50,000 for all of them. Can I just check in terms of, I guess both in terms of case law and also in terms of the thinking of this area, in what sort of circumstance would we find a limited or absolute limited or strict liability for an individual? I just want to get an example from the minister on when that would be applicable. I understand in terms of strict and limited liability for a body corp, which is in 2B, but if the minister wouldn't mind providing an example for 2A, that'll be appreciated.
Mr. Chair.
Before I attempt to respond to the member Lawrence Yunan's question, I just want to go back to the question that Rachel Brooking asked, the Honourable Rachel Brooking asked about the ability to turn water off. And there is a provision that 178A must provide necessary water and sufficient quantity, for instance, to provide for sanitation. So there is an ability to dial back the flow of water, but it still needs to be sufficient to, as I say, provide for sanitation, drinking, and so forth. So there's a balance that is applied there.
Chair.
It's a debate.
Honourable Director Brooking. Sorry, I just thought you stood down.
Sorry. Thank you. Thank you, the Minister. Thank you for explaining that part, and of course it's important that people can have some provision of water, but it was more then how does that link back to the earlier provision, which I know is in another part of the bill, that enables the water services provider to turn off if there's been a breach of a bylaw. Is that ability fitted by the clause that you just mentioned, that there must always be this provision for the good sanitary provision? And
thank you. The answer must be to that question, yes, it is fitted. Dr. Lawrence Zunan asked about existing protections against incrimination, whether they continue to apply, and the answer to that question is yes. And so without getting into a protracted discussion of the fundamentals of mens rea and the legal principles involved, I think he can be rest assured that those principles apply.
Dr. Lawrence Zunan.
Thank you, Minister, for that clarification. That was very helpful. I want to focus on the next section, which is 421. And this is, it's serious, but it's also really interesting that there is a section in here on that in terms of assault. And I just wanted to check with the minister, when we are looking at assault here, it says, well, intentionally threaten or assault. First of all, those two are a little bit different, but let's focus on the more serious of the two, which is assault. An employee or agent who is performing a duty of power, but the person who commits an offense against this section is liable on conviction for an individual to a fine not exceeding 50,000. However, I want to check with the minister that assault is a separate and a very specific offense under the Crimes Act 1961. And if we're looking at let's say, to give an example, under Section 173 of the Crimes Act 1961, assault with the intent to injure, the potential maximum conviction or criminalization of that is 3 years in prison. However, over here it's for an individual not to a fine not exceeding $50,000. In those kind of cases, are we looking at a person who might be charged for both under assault with the intent to injure? For example, there are other sections around Section 191 around assault, as well as what we see here in 421 in terms of intentionally threatening or assaulting an employee. Are those two going to be separate charges that's going to be placed on the individual? And if not, what then prevails? Are we looking at Crimes Act will prevail with assault with intent to injure, or 421 for this bill? Because it seems like if this is the case, you will potentially get a much lower conviction. For example, if you assault an employee or agent of territorial authorities or order organization than if you are assaulting with the intent to injure a person in general. So just want to get, unless we're looking at, again, so that may be part one, and part two is, unless we're looking at assault on a minor scale, but assault not necessarily with the intent to injure, which is, again, a very separate thing because there is a mens rea component to it, where simply assaulting may not have the same threshold for mens rea. But yeah, I just want to check in terms of what is meant by assault and its interaction with the Crimes Act.
Mr. Chair. The Honourable Scott Simpson.
This is turning into quite the law school process, and it reminds me of days long gone by. But I just want to confirm for the member that that provisions of this sort that provide protections for enforcement officers and agencies are pretty standard in legislation that is widely used by the New Zealand Parliament. So this is not an unusual provision from that regard. So to have those specific offences when undertaking compliance roles is common, not unusual, not weird, strange or odd in any way. And it is separate from general assault offences. And as the member will know from his own university lecturing days, that charging decisions are actually matters for prosecution, not for the legislation or the legislature. So that's the answer, the simple answer to that question. But it's an interesting legal academic point.
Mr. Chair.
Tom Rutherford.
I move the debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kau mā whā, ngā poti whakahe.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's tabled amendment to Amendment Paper number 346, deleting clause 347 bar 3, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
The ayes are 68, the noes 53. The question is agreed to. The question is that the Minister's amendment to Part 6 set out on Amendment Paper number 346 as amended be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Part 6, as amended, stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendment to Schedule 1 set out on Amendment Paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 1 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
Rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 2 set out on Amendment Paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 2 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 3 set out on amendment paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The noes have it. The party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti kore e whakaai.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 3 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No. The party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
Act New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 4 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 5 set out on amendment paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Tangi Utikiri's amendments to Schedule 5 set out on amendment paper number 342 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. A party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumawha e ngā poti e whakaai.
Act New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E rima ngā poti e whakaai.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Schedule 5 as amended stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Action New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 6 set out on Amendment Paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. A party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 6 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. A party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Action New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 7 set out on Amendment Paper number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Action New Zealand.
11 votes in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 7 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 8 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's tabled amendments to Amendment Paper number 346 amending Schedule 9 be agreed to. All those in favour say aye. Aye. To the contrary, no.
No.
The ayes have it.
No, have it.
Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendment to Schedule 9 set out on amendment paper number 346 as amended be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand
8
First,
votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 9 as amended stand part. All those in favour say aye. Aye. To the contrary, no.
No.
The ayes have it.
No, have it.
Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 10 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it.
Party vote.
Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 11 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's tabled amendment to amendment paper number 346, amending Schedule 12, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand,
Te kaumawha ngā poti e whakahe.
Act New Zealand,
11 votes in favour.
New Zealand First,
8 votes in favour.
Te Pāti Māori,
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that the Minister's amendments to Schedule 12 set out on amendment paper number 346 as amended be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National,
49 votes in favour.
New Zealand Labour,
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawā ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Schedule 12 is amended stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawā ngā poti e whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima ngā poti e whakahe.
The ayes are 68, the noes are 53. The question is agreed to. We now come to the debate on clauses 1 and 2. Tangi Utikere.
Thank you, Mr. Chair. Clauses 1 and 2 are fairly discreet but fairly important nonetheless. And so I want to talk to Clause 2 firstly, which is the commencement clause, which will basically indicate when this bill, if passed, would come into effect. Now, sir, I have an amendment paper number 342, which would seek to amend Clause 2, specifically Clause 2, Subclause 1, to replace that with the day after, replace the day after royal assent with the 1st of January 2027. Now, the effect of that would be to give councils and local territorial authorities more time to undertake the expectations and discharge the obligations that this bill would require of them. I don't think that is unreasonable. The Labour Party obviously is not supportive of this bill. However, if it is going to work for communities, communities need more time to consider what it is they need to do and to be able to give effect to that. Already around the country, sir, we are seeing examples of councils that are needing to rush around in order to meet the government's Sorry? They've had years. Well, there we go. So he said 3 years that they've had. Mr Hamilton himself has a background in local government. So what's really important here, though, is that communities are able to implement something that, quite frankly, will not work. It will not work. So the premise behind extending the commencement date and that specific subclause there is around giving councils more time to outline what their expectations are. Now, as this 3rd of September deadline draws closer, it's only a matter of days away, councils are being forced into a situation where they're needing to comply with certain things. It's optional. Oh, that's interesting. So as we move to Clause 2, Subclause 2, you know, this proposed change is about replacing the year 2026 to 2027, because this is not optional. This is a bill that is going to effectively require expectations. Well, that was the government member did say that this was optional. Now, I don't think that there are options. That where in this hefty bill is the option component. Well, I don't think there is one, because this is what is an expectation that will be required of communities all around the country. So my question to the Minister is around the commencement clause, what that looks like. The other amendment paper in my name is around Clause 1. This is the title. And, you know, often, sir, we hear in this House about the need to basically call a bill or an about to be act exactly what it is. And we hear from this government time and time again about how their water reforms are going to make a huge difference. They are going to make a huge difference. They're going to make a huge difference in the amount of money that households are going to actually have to pay in order to meet the water infrastructure needs of their community. That's the difference, what it's going to be about. So my final point, sir, is my amendment paper, which seeks to delete the words water services, and that this bill would simply be known as the Local Government Local Water Done Badly Act 2024.
Thank you, Mr. Chair, and I absolutely share my colleagues' concerns around the commencement dates. When we heard from councils as part of the select committee process, all of them were concerned about the timeframes. Now, everyone agreed that we want to be getting on with big changes when it comes to water reform, but not particularly in this way, and not particularly in this rushed way where councils are scrambling to meet these deadlines. So really support my colleague Tangi Utikire's amendment paper there. Now, I want to come as well to the title, and I want to emphasise how important it was in terms of this opportunity that the government did have to actually get this bill right. But when it comes to an appropriate title for the bill, I don't think simply saying local government water services is actually capturing what this bill is about. And I want to touch on a few aspects of why. The primary one, which we've had several, proposed amendments throughout the course of this committee of the whole stage, where we would actually centre the environment and particularly the adverse effects on the environment, where we know now in the objectives of this bill that has been removed. We also tried to put in place some very basic changes to the purpose, and this was really to ensure things like environmental sustainability, like access to equitable water services, things that are absolutely missing. And the concern with all of that is that it all adds up to provisions later in the bill when it comes to particularly the single set of stormwater and wastewater provisions, which again we've heard have very significant implications for allowing when consents come up for renewal or when consents are granted for new wastewater or stormwater treatment plants, that they can meet these single set of standards that are often many, many, many times more what is currently in place. And that all adds up to the fact that the impacts on the environment could be and will be in certain circumstances significant, and that is just entirely inappropriate. The other aspect that is really significant with this bill, particularly on those stormwater and wastewater standards, is the preclusion of either limited notification or public notification when it comes to actually involving the community in these decisions. So we know that these standards will override very significant democratic legislative processes and the legislation itself, and that cuts across national policy statements, it cuts across national environment standards, it cuts across regional policy statements, plans and district plans. And these are the core of how our democratic processes work in this country to actually set standards that should have teeth. And this bill is completely overriding that. So my proposal to adequately capture what this bill is doing is in my amendment paper to a change to clause 1, where we would call this act is the local government perpetually deprioritising community and ecosystem health water services bill. That's exactly what we're seeing here. The opportunity has not been taken up to prioritise community health and ecosystem health, and we absolutely do not support that, and we're really disappointed that the government have not made amendments to actually make sure that our people and our environment was central to all of this.
Mr Chair. Honourable Rachel Brooking.
Thank you, Mr Chair. I'd like to speak to those two amendments that have just been discussed in the previous two contributions by Tangi Utukuri and Lan Farm. They both make exceptionally good points. Now, going first to my colleague Tangi Utukuri, his amendment is for local government, for the title to be local government water services done badly bill. That's what the amendment is. And I was thinking during his contribution that probably it would be more accurate, in fact, if the title of the bill was local government water services done badly and more expensively bill. Thank you, Mr. Ukuri. Because that is the point. This is going to put more money on ratepayers, and that is a decision of this government. Shame on them. And then we go to Lan Farm's suggestion, which was I didn't catch it all, but it was again deprioritising the community and ecosystem health. And this is a very good point, because what this bill does, and it's not in the title at all, we can't see it, we just see water services and local government. There is nothing about the Resource Management Act and the further degradation of the environment that this government seems intent on doing with every bill that seems to come in front of this House. So in the Part 5 discussion of this bill, we found that standards are being imported into the RMA, and there was no comfort provided by the Minister that those standards would meet the purpose of the Resource Management Act, which is sustainable management. He said that they are there to improve water services, but it was unclear that they were going to improve the receiving environment, our rivers and coastlines, Madam Chair. So I think that Lan Farm's suggestion is a very good one, going to our ecosystem health, but also to our community health. And this relates back to my my suggested amendment to Tangi Utukuri's amendment, that this is going to put more expense on our ratepayers and some of our most vulnerable community members. So that is why the name of the bill needs to change. My preference is local government water services done badly and more expensively with worse environmental outcomes bill.
Steve Abel.
Yeah, sorry, I see the chair's changed. Thank you, Madam Chair, very much. Look, it's useful for us to reflect, as my colleagues have previously done, that this is a bill about water. The Secretary General of the United Nations 24 years ago says, access to safe water is a fundamental human need and therefore a basic human right. Contaminated water jeopardises both the physical and social health of all people. It is an affront to human dignity. So in speaking to the title of this bill and speaking to the failure of this bill to address the fundamental challenges we have in terms of local communities' access to safe and uncontaminated drinking water, I want to acknowledge that this bill, at least the Minister, refused the option for an amendment that ensured an equality of access to water. That has fundamentally disadvantaged our rural people more than any, because most New Zealanders, 80% of New Zealanders, have access to drinking water that is about 1 or lower in milligrams per litre of nitrate. But 800,000 New Zealanders, and that's a safe level of nitrate to be in water, 800,000 New Zealanders are exposed to potentially hazardous levels of nitrate in their drinking water, and they are mostly in rural New Zealand. So the community in Gore right now, 8,000 people who has not been able to drink their water a couple of weeks ago, they're now allowed to drink it, but it's still exceedingly elevated for nitrate. That is an example of where our rural communities are being failed by this legislation, because it does not allow the proper care of water services. I'll make a final point before I propose a new title for the bill based on this point.
I was waiting for the title and commencement piece.
I will give you a
come.
title, I promise you.
Thank you.
I'm giving you the context for the title. Those 800,000 New Zealanders who are most exposed to hazardous levels of nitrate, many of them are on household bore suppliers of water for under 25 people. This bill does not deal with those people. And those people are the ones that are most likely to be subject to the 100 cases of new bowel cancer every year and 40 deaths every year attributable to nitrate in drinking water in this country, New Zealand. Last night we had a bill which I proposed the title should be the Consenting to Cancer-Causing Contamination and Other Systems Bill. It was another water-related bill. This bill currently has the title the Local Government Water Services Bill. But to sharpen the focus of the community and the government on the fact that this bill is not addressing that critical problem of nitrate contamination, which predominantly comes from the dairy industry, I propose that this bill be called the Local Government Funeral Services Bill. Because there will be, Madam Chair, there will be people who fall ill as a result of the weakness of the water systems. It is absolutely serious. There are an exceeding high number of cases of E. coli that lead to serious illness and, in certain instances, death. And there are people who are dying from bowel cancer as a result of nitrate contamination. That's why I suggest it be called the Local Government Funeral Services Bill. Thank you.
Point of order, Mark Patterson. Honourable Mark Patterson.
I just seek your guidance here, Madam Speaker. There was some fairly outrageous claims made, and within the naming of that clause, there's more nitrates in vegetables than there are in water, so that's by far the way that people ingest nitrates in this country. So to draw cause and effect and essentially say this bill's, well, that's if you're talking about
this
nitrates.
Is a point of order, not a debate.
Yeah, so I think to draw the conclusion, the cause of effect, that the bill that the Minister's proposing is somehow going to kill people, I think is
look, I think I take the member's point of order, but there is literature and conversation out there about the points that Mr Abel raised, so I'm going to leave that there as part of the bill. Tom Rutherford.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes opposed.
That's the end, isn't it?
I never got to say my one.
The ayes are 68, the noes are 53. The question is agreed. Land Farm's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. Tangi Utikeri's tabled amendment to Clause 1 is out of order as not being an objective description of the bill. The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote is being called for. Please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma whā nā po te whakahe.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā po te whakahe.
The ayes are 68, the noes are 53. The question is agreed. Question is that the Minister's amendments to Clause 2 set out on AP number 346 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma whā nā po te whakahe.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā po te whakahe.
The ayes are 68, the noes are 53. The question is agreed. The question is that Tangi Utikeri's amendments to Clause 2 set out on AP number 342 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kauma rima nā po te whakaai.
ACT New Zealand.
11 votes opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E rima nā po te whakaai.
The ayes are 53, the noes are 68. The question is not agreed. The question is that Clause 2, as amended, stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma rima. Te kauma whā nā po te whakahe.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā po te whakahe.
The ayes are 68, the noes are 53. The question is agreed. Honourable Tamapotaka.
I move amendment paper number 345, dividing the bill.
The question is that the motion be agreed to. All those in favour say aye. Aye. Oh, sorry, I'm voting. Is there?
Sorry, it's debatable.
Oh, sorry. I've jumped the gun a bit here. I've just been advised it is a debatable motion, so I will call Tangi Utikere.
Thank you, Madam Chair. And look, I mean, it's unusual that we deal with a motion to divide a bill. It's not something that happens very often. So I've had a chance to look at the Minister's Amendment Paper 345, which seeks to do exactly that, and I appreciate that the content currently before the committee is a very discrete one around whether the bill should be divided or whether it shouldn't be divided. Given that this is something that does not happen very often, I think it would be helpful if the Minister and the Chair was able to indicate to the committee exactly why it is that he has sought to take this course of action. Certainly the Minister has moved the motion, but we have not received an explanation. The only explanation that we do have is what is listed on the amendment paper in the form of the explanatory note, which simply indicates that the AP divides this bill into the Local Government Water Services Bill and the Local Government Water Services Repeals and Amendments Bill. But there is no explanation currently before the committee as to why this course of action should be assented to by the committee. So I do hope that the Minister does take up that opportunity, because otherwise it would be that we would not be supportive of that at this particular point in time. The other question that I do have for the Minister in seeking this course of action is if it's to basically separate the fact that there is an existing piece of legislation known as the Water Services Preliminary Arrangements Act, and that some of the content in the bill, particularly what is sort of Part 5 and Schedules 5 through to 12, is related to that, and therefore it's redundant. It would be good to know that, but at the moment we can only infer that that might be the rationale or the reason for this course of action. Even having said that, it's important, I think, to understand that the bill as it currently stands would nonetheless, even if it wasn't divided, still provide avenues to address any of the concerns or opportunities that would be required for enactment. And so that's why it's a little bit perplexing as to why there is a desire to separate the two bills. It's certain that the Water Services Preliminary Arrangements Act would still continue to remain in place. I mean, it came into force it came to force on the 1st of July. Sorry, the Act is already in place, but this would seek to basically ensure that the two are separated. So the clarity, I think, is important. I'm sure colleagues on this side of the House may also have some points, particularly given that this is a very rare and unusual occurrence.
Dr. Lawrence Yunnan.
Madam Chair, I also welcome this opportunity to just ask the Minister a few questions regarding the motion, noting that the standard motion debate rules apply, that I only get this one opportunity to make this contribution. I echo the sentiments of my colleague Tangi Witakiri in terms of the rationale for the division of the two bills, since there is a non-existent explanatory note that is being provided in the motion number 345. But just for clarity for the Minister as well, in addition to the questions that are raised previously by Tangi Witakiri, additional questions I have is in terms of potentially the arbitrariness of the decision and the separation of Part 5 as a separate bill as opposed to other parts. The reason I mention that is because if we're looking at the second component of this bill, which is the Local Government Water Services Repeals and Amendment Act 2024, which splits out Part 5 and Schedules 5 to 12. One of the things that is of immediate, observation is Part 5 not only amends and repeals, but there are also other parts that do the same. So I'm curious to know, my first question to the Minister then is, if Part 5, which is amendments to other legislations, is split out, why did Part 6, which also includes additional amendments and two other legislations or miscellaneous provisions, in many cases when we're looking at Part 6 around offences and amendments to certain offences, isn't also considered as part of the second part of this bill. And also with regards to the idea of repeal and amendment, what I'm also not getting the clarity of within the second bill is what then is repealed and what then is amended. So under the previous provision, Water Services Provisionary Water Services bill that was introduced a couple of years ago, I don't recall, and please correct me then if I'm wrong, that things around civil defense emergency management, as an example, was also a part of that. So it would be helpful for the Minister to clarify that point. On to the schedules, while we're seeing that the schedules 5 to 12 to be also a part of a separate bill, we're also seeing that in 5 and 12 there are other things that potentially may interact with certain things that would be involved with the first part of the bill, which is water services. I think, for example, when we're looking at insertions into Commerce Act and also Local Government Act and water service preliminary arrangements, again, I understand if Schedule 8 is split out because it makes specific reference to water services preliminary arrangements, but it'd be good to know from the Minister why some of the other ones are also split out into the second bill, but not, for example, Schedule 1, which is around transitional savings and related provisions. And then finally, just overall, it would be good to have clarity from the Minister on why the bill needs to be split in the first place. We've only seen one other instance this term. I unfortunately wasn't here previously to know if this is a common occurrence for other bills, but this is only the second time we've seen such split of a bill in this term. So I wondered if this is something that is going to be more of a common occurrence as well going forward.
Honourable Tamapotaka.
Kia ora tātou. Part 5 amends and repeals several acts, and they are more of a substantial nature, the provisions in Part 5. Something similar happened actually with the recently amended gangs legislation in Part 6. It really contains more consequential amendments, so is retained in the initial bill.
Madam Chair.
Ryan Hamilton.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye.
Aye.
To the contrary, no. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma whānā poti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā poti whakahe.
The ayes are 68, the noes are 53. The question is agreed. The question is that the motion be agreed to. All those in favour say aye. Aye. To the contrary, no. Aye. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma whānā poti whakahe.
Act New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
E rima nā poti whakahe.
The ayes are 68, the noes are 53. The question is agreed. I will report this bill with amendment and so divided presently. Now, if members would just give us a chance to swap our paperwork over, we will shortly be moving on to the Hauraki Gulf Tīkapa Moana Marine Protection Bill.
Thanks, Chris. Whilst we're here, we'll go back over there or into the bathroom or
no, there has to be a minister in the chair. If you need to go to the bathroom, you might want to put Mr Ducey in there for a minute.
Minister Ducey. Minister Ducey.
You can have the other stuff. Right.
Just run to the little boys' room. Yeah. Just reporting back. We're going to come back and
starting that.
Yeah.
Thank you. Right, members, we now come to the Hauraki Gulf Tīkapa Moana Marine Protection Bill. We come first to Part 1. Part 1 is the debate on clauses 3 to 9A, preliminary provisions and Schedule 1. The question is that Part 1 stand part. Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. Madam Chair, this bill is the culmination of many, many years of collaborative hard work. Labour and government built on the work that was done through the Sea Change Tai Timu, Tai Pari, Hauraki Gulf Marine Spatial Plan, with a number of stakeholders that were brought together, iwi, hapu, local and central government, and various other entities that had interest in the Hauraki Gulf. There was then a government strategy that was developed in response to the marine proposals in the Sea Change Plan, a ministerial advisory committee that was set up to provide independent advice. Various interests in the Hauraki Gulf, Madam Chair, were balanced very carefully through this decade-long process. And that has led us over 10 years of work, and that has led us to where we are today. The Hauraki Gulf Tīkapa Moana Marine Protection Bill was introduced to this House. It had its first reading in August 2023. The Environment Select Committee, Madam Chair, considered thousands of submissions and reported back in June 2024. Members unanimously recommended that this House pass this bill with no substantive change. The second reading happened in November 2024, but, of course, prior to the second reading in November last year, Madam Chair, the Minister signalled that there would be some amendments, and here we are today. At the 11th hour, and we know why, the 11th hour, this government has decided to turn over or overturn or interfere with years and years of collaborative work to bring in a change that will weaken this bill, and here we are today, Madam Chair. Now, the Minister and the Chair tried to take credit for this bill during Scrutiny Week at Select Committee, and that's why I wanted to start by laying out that there has been many years of work by many players, and all this government and this Minister has done is to delay it and weaken it. And now that, since there's been no Select Committee process for the amendments, I want to read a few of the comments that we've seen in the media around these particular amendments, Madam Chair. Ngāti Rehua, Ngāti Waiki Aotearoa says, we see once again that money talks and that we are left with a degrading Moana. Because, of course, this is a bill that could have been passed in 2024, should have been, but it wasn't. And while that delay happened, while ministers were lobbied by the fishing industry to weaken this bill, the Moana has been degrading, and we've all seen that. Environmentalists are questioning the economic basis for the government's decision to weaken proposed marine protections in the Hauraki Gulf. We know that both DOC officials and fisheries officials were opposed to these changes on the basis that it will undermine the biodiversity outcomes and objectives, and that it would actually also lead to significant inequity. Madam Chair, over 32,000 people have signed an open letter to the Prime Minister, Christopher Luxon, asking that this government reverse the rash changes, these amendments that we're debating today, that allow fishing in the HPAs. And Madam Chair, Labour, if re-elected, will reverse these changes. Madam Chair, what I want to ask the Minister is really why. That is the question that everyone out there, outside of the fishing industry, is asking. What is the economic basis for this? Because all we've seen is about $14,000 of fishing revenue across all of the HPAs, which means it will be significantly less given the amendments allow fishing in 2 HPAs. So what is the economic basis? What advice, what evidence has the Minister seen on that? I also want to know what evidence, what advice the Minister has seen on the the impact on biodiversity objectives, specifically as a result of the amendments that he's bringing to the House today.
Rachel Boyack.
Thank you, Madam Chair. Madam Chair, I just want to take a short call on part 1 and indicate that I will have a lot more substantive comments to make and questions to ask in part 2, Madam Chair. And so a lot of the parts of this bill that I want to dig into are covered off in part 2. So just signalling that right now. So this will be just a short introductory call. I have a really specific question to the Minister, and it's off the back of Cabinet paper that was put forward by him, and the beginning of that Cabinet paper, and I'm just going to reference it in the beginning of the Cabinet paper, his own Cabinet paper from earlier this year, in relation to government priorities, that the National Party Blueprint for a Better Environment states that the National Party will accelerate initiatives like the Hauraki Gulf marine protection. And Madam Chair, why it's important that we take time today in this committee stage is that the Minister has tabled an amendment today that has not been through the select committee process. And so members on this side of the House, in fact all members, including members of the National Party and the ACT Party, who unanimously agreed to the select committee report and are now part of a government putting forward changes to that select committee report. We have not had the chance to look at that at a select committee, which means we do need to dig in today in the committee of the whole into why these changes have come forward. And so this is a paper put forward earlier this year, Cabinet paper in the name of the Minister for Conservation, Tama Pōtaka, that talks about government priorities. And here it is. I'm just going to show it to the House. Here it is, the National Party Blueprint for a Better Environment. So, Madam Chair, my question for the Minister is that the National Party promised to accelerate the Hauraki Gulf Protection Bill, promised to accelerate it, yet they have been in government for nearly 2 years. The Select Committee reported back 1 year ago, and what we are seeing now, 1 year later, is an amendment paper from the Minister, which essentially puts a delay. It has delayed this bill and it has weakened this bill. So my question to the Minister, has the Prime Minister Christopher Luxon and has the National Party broken their promise to New Zealanders? Because I put that they have. They have not accelerated this bill and they have weakened this bill, and that is my question to the Minister on the record today.
Madam Chair. Land Farm. Thank you, Madam Chair. And I would like to go straight to the purpose of the Act and keep this call very short, because I want to outline that, as we've heard from my colleagues, the implication of the government's amendments, which were put in place post the unanimous support of the Select Committee, have implications throughout the entire bill. So what I really want to spell out, because we've just been in Resource Management Amendment Bill and also Local Government Water Services Bill, and I'm very conscious, Madam Chair, that at times in both of those, but particularly in the RM Bill, there were allegations of repetition when it was not actually repetition, because it was actually relevant to that very clause. We're going to see the same thing with this bill, but it's in very different aspects of the bill. So I would really appreciate the patience and the allowance of us to do our due diligence in terms of this process. Thank you.
If the member points to the clauses at that particular time, that makes that much easier for us to see.
Thank you so much, Madam Chair. So what I want to ask when it comes to the purpose of this Act, and I'm really pleased actually that we have this purpose in place, but my absolute concern and what I would like to hear from the Minister is, given the changes that have been put in place with the amendment paper, particularly when it comes to the exemptions for commercial fishing in the high protection areas, and the fact that we know from the advice given that these had the ability to directly undermine the biodiversity objectives of the bill, does the Minister still believe that the purpose of this Act can be upheld given the amendments that are now in place. And I'd like to really clearly hear the Minister's response to that. Thank you.
Irene Williams.
Madam Chair, I have a number of questions for the Minister which relate to Part 1, particularly to his amendment paper AP 260. And they begin at Clause 4 of the amendment paper. I'm asking these questions up front in the debate because I hope that the Minister will answer some of our questions and concerns before I can ask about the specific parts. My first question is, why have references to whānau and hapu been stripped from the bill when they remain the first responders in dealing with environmental hazards, particularly kalupa and monitoring shellfish beds in the Hauraki Gulf? My second question is specific but relates to that. It is about why Ngāti Manuhiri and others who conduct vital restorations around Kawo Island have been excluded, given that they are a hapu and not recognised as an iwi group within this bill, or is that not the case because their trust board is Ngāti-wide trust board, which is not based where they are? If the Minister could help us to understand that, then that would be useful. Ngāti Manuhiri play a role of customary guardianship, and are they expected to down tools in their work that is actively protecting the Gulf from the invasion of kalupa while commercial access is being expended into these areas? I ask those two questions first because they are illustrative of the approach that we will take with further amendments that are on the table to reinsert whānau and hapu and make it clear about these groups which are actively engaged in protections within the Gulf currently, who may not fall within the Minister's new definition, which has excluded whānau and hapu from it. It would also be helpful if the Minister could contextualise these changes with what the intentions are of the government with its policy towards MACA claims, marine and coastal area claims, which are all based around the rights of whānau and hapu in this area. The Minister will know that around 44 MACA claims are live and active in the Hauraki Gulf area, and so it's important that we consider those changes alongside this change. This amendment paper, Madam Chair, and the questions that I have about it to Part 1 are made in the context of 11th hour changes after 10 years of careful negotiation with stakeholders and various interests in the Gulf. And so why I ask the Minister's clarity before we get into the specific parts is we have to understand that a number of hapu, a number of whānau are actively engaged not only in consultation about the precursor of this bill, but also the general policy and Tai Timu Tai Pari sea change that has been a collaborative, collegial and empowering process for those groups. Recognising Crown obligations under Te Tiriti o Waitangi requires us to engage not only with iwi, not only with fisheries rights holders at a trust board level, many of which are creatures of legislation themselves and have existed since the 1990s. These whānau, these hapu who go out every day and monitor the shellfish on Waiheke, monitor the kalupa invasion at Great Barrier Aotearoa, are not included within the definition of what you might expect for an iwi trust board and are certainly not the fisheries rights holders themselves. I want the Minister to clarify whether it is his intention to exclude them from the process and to only prioritise the rights of Māori, who are the holders of fishery assets, at the legal body which holds those assets level, which is the trust board or iwi level. The Minister needs to be very clear with not only environmental NGOs but with iwi Māori whether it is his intention to exclude those voices of the people on the ground who get up every day to get into their moana, they put their dive gear on, they look for the crays, and they are doing the work for all of us.
Honourable Rachel Brooking.
Madam Chair, like my colleagues, I think most of us will be focusing on the Minister's big amendment paper. I've got that at 260. So I want to start, and like other people making contributions, I too will be focused on the Minister's amendments, but of course they do relate to the rest of the bill, as Lan Farm just pointed out, with the purpose of the Act and whether or not his changes actually now undermine that. But I want to go to the interpretation section, and I'm interested in some changes here around both the department and the Minister. I see that we've also got definitions for grey mullets and some other fish as well, which is lovely, but that is not my focus. It is on the department and the minister. And I am, of course, interested in this because when this bill was introduced in 2023, I was the Minister for Oceans and Fisheries, and we were very pleased to introduce this bill to get it underway before the election. But the bill was always in the name of the Minister of Conservation, and the bill at the moment is in the name of the Minister of Conservation. But I'm wondering if these changes to the definition of department and minister really open up the Act, and we'll get to it in a later section about who gives out permits and who does regulations, but that's not in part one. If this is setting up the Act to be administered by the Ministry of Primary Industries, so the fisheries component of that, rather than the Department of Conservation. And that would be a large change. So that is my question, is that why this is changing? I have some other questions on part one, but I'll come back to that.
Honourable Priyanka Radhakrishnan.
Thank you, Madam Chair. As my colleagues have said, have pointed to, we do have a number of questions that relate particularly to Amendment 260. But just before I get into the detail of that, I have three specific questions for the Minister, given again that these amendments have a bearing, have an impact on the bill in its entirety as well. So firstly, I want to know what advice the Minister has considered, what evidence he has seen that has led to his claim that the amendment to allow fishing in high protection areas will not undermine the biodiversity objectives of this bill, given that his own officials and environmentalists have been very clear that they will undermine the biodiversity objectives of the bill. The second question I have is in relation to the Minister's comment that his rationale for allowing fishing in HPAs is this government's response to the cost of living crisis in New Zealand. He has said that this helps people facing a cost of living crisis, many of which don't have the ability to access this fishery. Now, his claim, his rationale, has been met with heavy criticism, including from Ngāi Taiki Tamaki, whose island, Metutapu, is one of two areas where fishing will be permitted as a result of the changes in Amendment Paper 260. They have said to claim that this decision has been made in response to the impact of cost of living increases for Māori and Pacific whānau, and then specifically for South Auckland, as a justification for allowing commercial enterprise in this area is weak. They have then gone on to say that this is the first that they have heard of this rationale, and has hoped that the claim can be backed up by MPI's Fish Serve data. So that's my second question to this Minister. What data backs up this Minister's claim that this is the government's response to the cost of living crisis? The third question that I would like to ask the Minister is around a claim that has been made in the media by Seafood New Zealand. We know, of course, that they have lobbied Minister Jones for this change, and the Conservation Minister has had to now backtrack and ensure that the amendments brought to this House that we are considering today will actually break the promises that this government has given to New Zealand to accelerate this bill and to improve the health of Tīkapa, Moana, Hauraki Gulf, neither of which they have actually delivered. So my third question is, Seafood New Zealand has said that these exceptions are grandfathered, meaning that once these fishers leave the profession, no one else can fish where they fish. Where in the bill, where in the amendments, Minister, are the provisions to grandfather these permits?
Celia Wade-Brown.
Thank you, Madam Chair. My questions go to Clause 3 and the purpose, and I would be interested in the Minister's experience in working with his colleague in tourism and the role that sustainable tourism and protection of the natural environment work together. A number of the submissions to the Hauraki Gulf Tīkapa Moana bill, particularly when they were unaware of the recent changes, did talk about the opportunities for sustainable tourism. And I wonder whether he feels that the purpose in some ways is still a little narrow, in that it's not talking about the restoration of economic opportunities as well for well-protected marine areas. And looking, as our Moana connects us to the rest of the world, I had an example that may be, in my view, is quite an inspiring example, very recent. Earlier this year, Argentina expanded its marine protected areas in a Patagonian area which has got low tourism numbers, unlike, of course, Cathedral Cove. And they really felt that integrating regenerative principles into tourism would optimise economic benefits for those coastal communities while safeguarding natural resources. And I feel that this bill is to some extent still a siloed approach, doesn't refer to the wider benefits. And I wonder if the Minister feels that some mention of those opportunities that were referred to in submissions would help see how we can actually manage those really low impact activities. I'm talking about kayaking, snorkeling, scuba diving, without the catching aspect of it, and whether that aspect has been overlooked in the purpose of the bill, and to what extent those changes that have come in after the consultation. I went back, not having the enjoyment of being on the Environment Committee for seeing this all its way through, but I went back and looked at them, and of course there are so many organisations saying, we stand by this bill, this is a wonderful bill, we agree with it, and then those changes came in later. So I look forward to elucidation from the Minister on those points.
Thank you. I'm going to take a call from the Minister. Just before I do, I just wanted to clarify the questions that have been asked about whānau and hapu. Technically they're in part 3, but I'm going to allow the Minister to answer that question because it fits in the interests of iwi that are in this part 1, and I think it will help to clarify that early rather than having to wait for part 3 for that to be clarified. So, thank you. Honourable Tamapoti.
Ngā mihi te tiamana, and I respect and appreciate your kindness in that regard. Kia ora te marino, kia whakapapa paunamu te Moana, kia tere te karohirohi ki mui a tātou. May the widespread be calm, may the oceans glisten like greenstone, and may the shimmer of light guide your way. There are a number of people I can acknowledge, from those who are involved in the initial work around sea change in the time of the key English government, through to those legislators, some of whom are still inside the House today, who embarked on this mission to increase the marine protection in Te Pātaka Kaya ki Tīkapa Moana, Te Moana Nui a Toi Te Huatahi, but particularly those community iwi, commercial, business, charitable organisations that were involved over time to ensure that the marine protection of this iconic and majestic place is elevated and indeed accelerated, hopefully this week and next week, to receive the royal assent soon thereafter. There have been a number of questions that have been asked, particularly around the ringnet fishing, which I think is in part 2, but I'll deal to them right now in order to enable a more focused line of questioning when we get to part 2. Of course, the questions around ringnet fishing in some ways reflect the environmental pragmatism that this coalition government is bringing to a number of environmental laws, and the difference between ideology and implementation, excitement and execution. And whilst there are views, strong assertions that there is unanimous support across the House, as evidenced by the Select Committee comments, I might represent that not all parties in this House are represented in that select committee. So let's not fall for perception, but get back to reality. The acceleration of this legislation is critical. After 6 years of a previous government seeking to progress this legislation, we have now got the ball and will take it over the line. Despite the majority government that existed for 3 years, and legislators across the other side of the House know this, we are unable to secure the final readings, which will come in the next week or two. In terms of the amendments proposed, will the purpose be upheld? Absolutely, the purpose will be upheld, but let's not get caught in the extremities of an ideology that might not be able to procure an enduring solution for these matters. In terms of the ringnet fishing, there were questions that were asked around the impact that it will have on biodiversity objectives. And as you know, as members of this House who voraciously read the amendment papers, amongst other things, it's not the only fishing that takes place in the high protection areas, is it? No, it's not. So in the high protection areas, there is fishing that takes place. You got it. So let's be careful not to assume that there is no fishing in the high protection areas. There actually is fishing there. In addition to that, I'm advised that there will be limited impacts on the biodiversity objectives by this very narrow and acute provision for ringnet fishing. There are practical thresholds that we work with and we seek to facilitate in the engagement and consultation and liaison processes around not only iwi, whānau and hapu engagement, but also community engagement. Hence why the elevation of iwi rather than whānau hapu iwi has been proposed. That does not mean whānau and hapu miss out, as the member would understand, but there are ways to channel that in a more efficient and deliberate posture than what was earlier proposed, and that's why we have used the iwi in the amendment rather than whānau hapu and iwi, but whānau and hapu continue to participate at an iwi level, because as members know, all whānau and hapu have iwi. The allegation that Ngāti Manuhiri is not an iwi, I don't think will fall very kindly on the ears of the co-chair of the Hauraki Gulf Forum, Nicola MacDonald, and or her partner and thick as thieves partner, Mokonic, who continually remind us that Ngāti Manuhiri are an iwi. But I need not resort to Te Kāhui Māngai and the list of iwi that exists on the TPK website. In relation to the rationale for allowing fishing and the comments made about the great iwi of Ngātai ki Tāmaki, I actually talked to the leaders of Ngātai ki Tāmaki, unlike some other members of this House, and am well ensconced in their views around progressing the marine protection that is currently articulated in the bills and the amendment papers. And they are absolutely enthused by the approach that has been taken to get this bill to a third reading and over the line, rather than ongoing pontification about the ideological extremes of environmental radicalism. So we will get this moving. Seafood New Zealand, yes, they've made comments, but they are not the legislators. We are. They do not have parliament.nz or parliament.gov.nz on their emails. However, we will have a 3-year review. And that 3-year review will check in on whether or not the ringnet fishing is appropriate, and I'm sure that it will be one that is topical and will go long into the evening. There were other comments around guaranteeing that all fish caught within the areas will supply local communities, those that are interested in kahawai, trevally and grey mullet, typically of low interest to the export market. And again, whilst we cannot trace where every single fish caught actually goes, we do know that these types of fish are generally destined for domestic consumption and more affordable than other protein options, whether or not that's pea protein, whey protein, or fish protein. I think that's probably captured most of the questions that have been asked, and I'm sure that the part 2 questions will be a lot more narrowed accordingly.
Land Farm.
Thank you, Madam Chair, and I want to thank the Minister for at least attempting to address these very serious concerns that we have. Now, the first thing that I wanted to pick up on was the Minister's comments about the extremities of ideologies and environmental radicalism. And he talked about that in the context of what he described as environmental pragmatism. And a genuine question that I have about that is, does the Minister's environmental pragmatism, as he so calls it, actually align with ecological evidence? And I'm interested in asking that because we also just heard the Minister say that actually DOC has advised that the ring net exemptions will have minimal impact on biodiversity objectives. And I'm wondering how that aligns with previous advice that it risked undermining the biodiversity objectives. So if the Minister could please clarify how that works. Maybe DOC has more information or new information that was that we're unaware of. So really keen to hear that. Now, I want to also move to Clause 5 in the interpretation, and my comments and amendment paper on this are on page 7 of the government's amendment paper to the bill. Now, why it directly relates to the biodiversity objectives question, which I'd be really keen to hear a response on, is because it's about the very description itself and the definition of these so-called high protection areas. Now, what I would like is direction and information about that, because from my understanding of it, is that it would be inappropriate to call these areas high protection areas, and my proposed amendment is to actually replace the definition of high protection area with compromised protection area, and that could be more in line with the advice that the Minister has given or received from DOC, if that is the case, because we're yet to hear a definitive answer on that. Now, that would mean that in every mention of high protection area, that would then be replaced with compromised protection area. And I think it would be really valuable for the Minister to directly address how can an area allowing commercial fishing still be considered a high protection area, and is that definition in need of amendment to actually align with the advice that he's received, with the environmental evidence? Because what we also know about these high protection areas is some of them are of huge ecological value. It is areas like Tiriti Matangi, actually, that the select committee that I was on when we considered this bill actually visited, and we got the whole show, including dolphins. And it's of critical importance, because if this bill is actually going to achieve the things that it says it's going to achieve in terms of improving biodiversity outcomes, we need to be really clear about what we're saying and why, and whether these areas are truly compromised or otherwise. So really keen to hear advice from the Minister. Thank you.
Honourable Rachel Brooking.
Thank you, Madam Chair. Still on part 1, and very specific questions to part 1. The Minister didn't answer my question about changes to Clause 5 interpretation around the Department and the Minister. Are we moving from conservation to fish? And then I'm also interested, he might want to comment on the definition of ring net fishing means the use of a ring net for fishing, if that's specific or not, enough or not. But then I also want to touch on at 5B, this is how this Act applies biodiversity objectives, and D has been struck out, which refers to another part of the bill, which is section 67, provides for the making of regulations. He might want to touch on why that regulation power appears to be being removed. Is it because, is it his opinion that everything in this bill is already sufficient to achieve the biodiversity objectives without the need for a regulation? Or is there some other reason for that deletion? And we can come to it in a later part as well. I also want to go now to 9A across the page on page 12. And this is the no entitlement to compensation. And this has been struck out. So where before it was clear that the Crown was not liable to pay compensation, now that's gone. So presumably the Crown is now liable to pay compensation. That seems to be a rather large policy change, and it would be good if the Minister could tell the House why it is that he thinks that there should be that ability for the Crown to provide compensation, and also if he has any advice on what the magnitude of that compensation might be and when that might have to be paid, and that might relate to questions later in the bill about grandparenting of ringnet fishing, but it seems to be actually well beyond the ringnet fishing changes that we've got coming up. This is for presumably everything that is happening at the moment that will change because of this bill passing. So I'm very keen to hear about compensation. I'm also keen to note that the Minister in his wide-ranging contribution before talked about being pragmatic, and it appears that his definition, and it's one that I hear a lot from government parties, is just to make environmental effects worse. And he then says that we on this side of the House are idealistic. And I'm wondering if his definition of idealistic is just when people want to improve the environment. Is that what he's talking about? That idealism is wanting to improve the environment, whereas pragmatism is wanting to make the environment worse?
Running out of questions.
The Honourable Priyanka Rose.
Did you say my name?
Yes, I did.
Oh, yes,
sorry.
I didn't hear. Thank you, Madam Chair. Look, it is a shame that the Minister wasn't able to provide any evidence around the impact that the particular amendment would have on biodiversity outcomes, or how he shores up his claim that this will go to communities in South Auckland that need additional protein. However, my questions specifically are around particular clauses in Part 1. One is around that definition of ringnet fishing, and given that the Minister did not respond with any evidence around the impact of the ringnet fishing, and given that the definition of it is in Part 1, I do want to draw his attention to comments that have been made in the public domain, bearing in mind that these amendments have not gone through a select committee process. All we can rely on in terms of comments from stakeholders are through conversations or through what they've said in the media. And so I refer to what has been said by WWF in the media around allowing commercial fishing to occur in these high protection areas. They have said that the type of fishing that is allowed to continue, which is of course ringnet fishing and is set out in the definition, is very similar to purse seining and targets bait fish species that congregate in the mid-water and which predator species like snapper rely on for survival. Key species like the kahawai are already overfished in the Hauraki Gulf. And the impact up the food chain is evident when you look at snapper populations and how emaciated they are as well. And given that kahawai is included in in the type of fish that will be allowed to be caught in the high protection area. Again, I ask the Minister, what is the impact on biodiversity objectives to those types of fish that we're trying to protect by bringing in a high protection area, which is just below the no-take marine reserve when it comes to the hierarchy of protection? That is my first question, Madam Speaker. Going on to clause 5B1, subsection 1D, which is deleted, which is removed from the legislation by this amendment in Amendment Paper 260. My question is why? Basically, 5B1D lays out that Section 67 provides for the making of regulations that provide additional management actions relating to HPAs, where the restrictions that are imposed by the regs made under Section 66 are insufficient to meet the biodiversity objectives. So no idea what the Minister's doing in the chair, but I don't know how this makes any sense in terms of it being deleted. And so that's my second question to the Minister. The third question that I have, also relating to Part 1, is to Clause 8A. I get the signposting in Clause 5, I think it is. Well, the signposting of the treaty settlements, that's fine, and it's explained in the Cabinet paper as well. But 8A, I understand, is quite unusual. So I'd like the Minister to explain why this clause has been introduced, and when it specifically relates to existing treaty settlements, is it in there because there are some future treaty settlements that will be excluded from this particular clause? If not, why has this clause been introduced?
Yeah.
The Honourable Tamapotaka.
Thank you for those various questions and one frivolous suggestion around amending the Act, the bill. So in relation to the point around which department is responsible for the administration of the Act, I think members will be aware that there have been budgets committing to an appropriation to support the implementation of the Act once passed. They retained within DOC, and of course the Department of Conservation, particularly with the recent appointment of the regional manager in Auckland, have significant depth around understanding the nation. I don't know what that outburst was about, but have significant depth around the implementation of the bill once passed into legislation. So that's my expectation. I don't think that there's anything untoward or sinister in the wording of that provision, that clause. In terms of clause 9 and the 9A and the no compensation clause, there is some consistency with the approach being proposed with the marine reserves legislation, and the economic impact analysis suggests that there's no situation here that would warrant a claim for compensation. So it's not expected, it's not expected that there will be claims as the impact of setting out and implementing both SPAs and HPAs would not be significant enough to warrant compensation. In terms of Section 67 and 5BD, the bill proposes that customary non-commercial fishing does not sit within the establishment of the biodiversity objectives and plan. One of the reasons why is because customary fishing is actually managed under the Fisheries Act, and we do not believe that it is warranted or suitable to add yet another layer of bureaucracy on the exercise of customary, or could we say tikanga, responsibilities within the Hauraki Gulf. So I think, again, people might think that there's something unusual going on here. It's not. There's a degree of efficiency between 66 and 67 now that we are proposing to remove customary non-commercial fishing from the ambit of the plan around biodiversity. There is no longer any need to have both of those sections, and we've collapsed them together. There's one more note. I think I've touched on that. Yeah, standard drafting in relation to the department question that the member Brooklyn had. Is the purpose of the bill too narrow as it doesn't refer to benefits of low impact activities such as sustainable tourism? No, we believe that the purpose of the bill is the protection of the environment and the rights and interests and responsibilities of mana Moana, but we do anticipate benefits for tourism, and as someone who's had the responsibility to apply for, seek and prosecute concessions in the Gulf for tourism purposes, of a little bit of understanding around how those processes operate and the potential for those tourism interests to actually increase and enlarge as a result of more environmental protection and marine protection in the Gulf, but also the consequential benefits that come from that, whether or not that's more fish or molluscs or crustaceans, seaweed and other things that often attract people to the marine space. I think that might have been most of the questions that have been asked in the past few minutes. So I might take a seat, Madam Chair.
The Honourable Kamel Cipollone.
Yeah. The Minister himself just said in his comments that he understands some may think that something unusual is going on, and then he proceeded to defend their stance on the changes they've made. But I think that was a really important point. The point I want to make is around consultation and questions in relation to that. Given the Minister has introduced 11th hour changes to the bill that effectively weaken it, when back in 2022 there was extensive engagement with all those that wanted to make a contribution or add their thoughts to this legislation. I think the Minister really needs to answer to this House and to the general public, particularly Aucklanders, who were the stakeholders that influenced the 11th hour changes that have seen an amendment put up that effectively weaken legislation that had been agreed on and consulted on and had a consensus drawn after 10 years of work. Madam Speaker, he especially needs to answer to this House and to Aucklanders who those stakeholders were that have influenced these 11th hour changes, given that the change was not supported by officials or by any of the environmental NGOs, and more than 30,000 people signed an open letter urging the government to reverse its decision, with over 5,000 emails being sent to ministers in protest. And so my question to the Minister, on behalf of Aucklanders and all those who care about the Hauraki Gulf, is who were the very important stakeholders that influenced the 11th hour changes that weaken this legislation?
Aaron Williams.
Madam Chair, delighted to be able to take a call in support of my colleagues' questions. The reason I have asked the Minister about the exclusion of whānau and hapu in relation to this part is that his amendment 260 in his name makes changes to the way that Te Tiriti o Waitangi, the Treaty of Waitangi, will be treated in this Act, and we need to be clear how the interaction between his 4.1, this Act must be interpreted and administered so as to give effect to the principles of Te Tiriti o Waitangi, should be read when his changes later in the bill take whānau and hapu out, because it is well-established law that when giving effect to the principles of Te Tiriti o Waitangi, government, its departments and any agent acting on its behalf should consider not only iwi Māori but also whānau and hapu. And so that is why I have asked him specific questions about Ngāti Manuhiri, and he has said that that is an iwi, that is good, and that should stand on the record here in Parliament that they are intended to be considered an iwi under this legislation, and that there could be no question of that later on. And so then I will ask him about every single hapu who is standing to lose under his changes. Minister, what are the safeguards to protect Ngāti Whātua Ōrākei's 20-year mussel bed restoration at Ōkahu Bay from being undermined by your amendments? What are the protections for the Tamaariki whānau who have been involved in that restoration project for more years than I have been alive? What is the protection of their legacy and their whakapapa connection to that bay? What are the protections because they are not, in the ordinary meaning of the word, an iwi? What are his protections, given that he has explicitly made a change at the 11th hour to remove the rights and interests of whānau and hapu for all of the Māori of Auckland who love the Hauraki Gulf? Aucklanders love our Gulf and we need it to be protected. Why is he not standing up to Shane Jones when it is Shane Jones's changes at the last minute that have removed protections for the Māori who get up every day to put on their wetsuits and count the quota, to get rid of kalupa because it is invading our Gulf and our Moana? We do that work for everyone, and we have worked for 10 years to get buy-in from stakeholders all around Auckland so they can agree to what is a huge and significant step forward. And I hear government members saying that we have done nothing about it when we have fought for 6 years and introduced this legislation and worked with stakeholders so it is enduring. We worked for cross-partisan support for this because the whānau and the hapu who do this work for all of us should be protected. Just to lose it at the last minute, to vested interests, to lobbying that has gone on behind the scenes that none of them were included in. Why, Minister, are you breaking the promise that you have made to Aucklanders? Madam Chair.
Rima Nutley.
Madam Chair.
I move that debate on this question now close.
Madam Chair.
I'm just noting the repetition that I'm hearing in a very short time and what I've heard from my office. So I'm just letting members know we're looking for new material and interrogation of the detail within the bill. Lan Pham.
Chair.
Point of order, Priyanka Rahakrishnan.
Madam Chair, I'd just like to point out that there have been a number of questions asked that the Minister has not actually addressed at all.
That's not a point of order. Lan Pham.
Madam Chair.
Point of order, Arana Williams.
Thank you, Madam Chair. Just speaking to Standing Order 66.2, I note that there's a convention that in committee members in charge of the legislation should not be chipping from the hot mic in front of them. The Minister has done that a few times now.
I'm sorry, I missed what you just said. Can you please repeat that?
Sorry, Madam Chair. I'm referring to, in the Speaker's ruling, page 66, it's item 2 on the page. It's a long-standing convention that the Minister and the Chair in a committee say shouldn't sort of chip from the mic, or as is the colloquial term, but using the hot mic in front of him to disrupt proceedings, and so I hope you can offer him some guidance.
Lan Pham.
Thank you, Madam Chair, and I just have a very quick, direct question of clarification from the Minister based on his response. And this is particularly in regards to Clause 5 in my proposed amendment paper. Now, when the Minister mentioned a frivolous amendment paper, I'm interested in firstly hearing whether he was referring to this one, because I have not heard a direct answer about the actual advice that he's been given from DOC, because he said that there would be minimal impact on biodiversity objectives. He said DOC advised that there would be minimal impact on biodiversity objectives, when the information that we've had, again, DOC's official advice is, quote, that allowing ringnet fishing would undermine the biodiversity outcomes of the high protection areas. Which is it? What evidence and what advice has DOC given the Minister to back up the minimal impact on biodiversity objectives?
The Honourable Priyanka Rahakrishnan.
Thank you, Madam Chair. Madam Chair, I rise to take a short call on a specific aspect of this amendment, and that is around the customary non-commercial fishing that the Minister made some points too, and I have some questions to him based on his response that was given previously. And I was just looking for the bit in the cabinet paper that lays out the government's rationale for the change here that will mean that customary fishing is only subject to the Fisheries Act and not required to uphold the biodiversity objectives of this bill. And I point to the bit in the CAB paper that just says that it's removed from the scope and the regulations. And there isn't a lot of rationale as to why. I have one quick question to the Minister. Submitters had noted that removing the biodiversity objective requirement risks weakening public acceptance of customary fishing in HPAs. That was a point that was raised by a number of submitters to the Select Committee, many of whom were opposed to the provision of customary fishing within HPAs. Now, I am grateful that the Minister has retained the provision for customary fishing. However, by removing the requirement for it to meet biodiversity objectives and the amendment just pointing to the Fisheries Act, I would like the Minister's response as to whether he accepts the point that is made by submitters that the social licence for customary fishing is stronger if it is subject to the requirement to meet biodiversity objectives, and if not, why not?
Honourable Rachel Brooking.
Thank you, Madam Chair. Just a quick reminder to the Minister that, of course, we have not had any Select Committee process over his amendments, and I did not hear him talk about the removal of compensation, the 9A, and I think that's very important. Well, I didn't hear a very good explanation then of what analysis had happened about what the consequential cost could be of this removal so that compensation can now be paid. And I also heard him say something, I did hear him mention my name in answering a question, but I don't think he's addressed the department and the Minister, unless that was the piece where he was saying that the newly appointed regional boss of DOC, there's another name for it that's not boss of DOC, but the regional person, is expected to undertake it. And so if that answer from the Minister was in relation to my questions about the new definitions of department and Minister, it would be helpful to clarify. Thank you.
Madam Chair.
The Honourable Tama Potaka.
Can I just make a couple of quick comments in responses to questions? One of them was around what evidence has DOC provided to support the statement. Yes, the earlier advice did say that ringnet fishing risks undermining biodiversity objectives, but the more recent advice is that given the work, the diligent work that Te Papa Ātawhai has taken with the fisheries teams across government and the carefully considered and manicured conditions that now apply to the ringnet fishing will ensure that any environmental and biodiversity impacts beyond those species will be very limited. So I think that there's been some very positive and constructive work taken by officials to ensure that the conditions are appropriately worded to minimise the impact, and I think we've spoken about that maybe 4 times now, Madam Chair. In relation to the assertions, unhelpful, that there was consensus across the House, not in this term. That has been articulated in a variety of ways in my comments today, particularly around representation on the Select Committee, but also that this House has a different composition to the House of 2020 to 2023. There has been a degree of questioning around the treaty settlements and that there will be no impact for the avoidance of doubt, no impact. The clauses that have been proposed provide that all settlements, current and future, will be given effect to. I'll just look over my notes, Madam Chair, because, again, there have been a couple of repetitive elements. And there was actually a question also by someone who is currently no longer sitting in the House, seeking to have a long list of all the different people that we have engaged. There have been literally thousands of people that have engaged over the last couple of decades in relation to this important piece of legislation, and we have again received the responsibility to carry it through to enact, and with that, it's a great privilege for me to stand and respond accordingly. Thank you very much.
Catherine Wedd.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour, please say aye. To the contrary, no. The ayes have it. A party vote is called for Mr Clark.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
In favour.
Te Pāti Māori.
5 votes opposed.
Probably 3/4 of that was parts 2 and 3.
The ayes are 68, the noes are 53. The question is agreed to. The question is that Arana Williams' tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with kaitiaki, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. The ayes have it. A party vote, please, Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Arana Williams' tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with those, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. A party vote is called for Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Arana Williams' tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with mana whenua, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The ayes have it.
Noes have it. Party vote.
A party vote is called for Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Pardon me, 14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Arana Williams' tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with Māori, particularly hapu, whānau, hapu and iwi, be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. Party votes called for Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with groups of Maori be agreed to. All those in favour, please say aye. To the contrary, no. No. The noes have it. A party vote's called for, Mr Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams tabled amendment to AP number 260, amending clause 4 brackets 2 brackets E, replacing iwi with stewards be agreed to. All those in favour, please say aye. To the contrary, no. No. The ayes have it.
Noes have it. Party vote.
A party vote's called for, Mr Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams tabled amendments to AP number 260, amending clause 4 brackets 2 brackets F, replacing iwi with kaitiaki be agreed to. Those in favour, please say aye. To the contrary, no. No. The noes have it. Party vote is called for, Mr Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendments to AP number 260, amending clause 4 brackets 2 brackets F, replacing iwi with whānau, hapu and iwi be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. Noes have it. Party votes called for, Mr Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendments to AP number 260, amending clause 4 brackets 2 brackets F, replacing iwi with those be agreed to. All those in favour, please say aye. To the contrary, no. No. The noes have it. Party votes called for, Mr Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendments to AP 260, amending clause 4 brackets 2 brackets F, Replacing iwi with mana whenua be agreed to. All those in favour, please say aye. To the contrary, no. Noes have it. Party vote, please, Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendments to AP number 260, amending clause 4 brackets 2 brackets F, replacing iwi with Māori, particularly whānau, hapu and iwi be agreed to. All those in favour, please say aye. To the contrary, no.
No.
The noes have it. A party vote's called for, Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendments to AP number 260, amending clause 4 brackets 2 brackets F, replacing iwi with stewards be agreed to. Those in favour, please say aye. To the contrary, no. Noes have it. Party votes called for, Mr Clark.
New Zealand National.
Whā tukona iwa whakahe.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendment to AP number 260, inserting the definition of iwi in clause 5 be agreed to. All those in favour, please say aye. To the contrary, no. Ayes have it.
Noes have it. Party vote.
Party votes called for, Mr Clark.
New Zealand National.
Whā tukona iwa whakahe.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that Aaron Williams has tabled amendment to AP number 260, deleting the amendment to remove clause 9A be agreed to. All those in favour, please say aye. To the contrary, no. The noes have it. A party vote's called for, Mr Clark.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
14 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 opposed.
Te Pāti Māori.
5 votes in favour.
The ayes are 53, the noes are 68. The question is not agreed to. The question is that the Minister's amendments to Part 1 set out on AP number 260 as amended be agreed to. All those in favour, please say aye. Aye. To the contrary, no. No. The noes have it. A party vote is called for, Mr Clark.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
ACT, New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed to. Land Farms tabled amendments to Clause 5 are ruled out of order as being merely an attempt to criticise the bill. The question is that Part 1, as amended, stand part. All those in favour, please say aye. Aye. To the contrary, no. The ayes have it. A party vote, please, Mr Clark.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
14 votes opposed.
ACT, New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori.
5 votes opposed.
The ayes are 68, the noes are 53. The question is agreed to. Members, we come now to Part 2. This is the debate on clauses 10 to 25, marine reserves, seafloor protection areas and high protection areas, and schedules 2 to 4. The question is that Part 2 stand part. Rachel Boyack.
Thank you, Madam Chair. I have been waiting for the opportunity to take a call on Part 2. And, Madam Chair, this is where we do dig in into a little bit more detail about the amendments in the Minister's paper that he has tabled that make some changes around ring net fishing in particular. So I'm looking at Part 2, Clause 19A on page 16 of the Minister's tabled amendment paper. And I do just want to note again that we haven't had the opportunity to have discussions about this particular amendment in select committee. There hasn't been an opportunity for stakeholders or for members of the public to make submissions to a select committee or for MPs such as myself to be able to ask questions of officials. So we are looking forward to having some comprehensive answers from the Minister. And mine is quite specific. So I just want to come back again, and I've already referenced it today, and forgive me while I find it. I think I might have lent it to somebody else, the Cabinet paper. Good times when you, yes, I have. I've loaned it to a friend and I've got it back, so that's great. There's a section in the Cabinet paper. So this is a Cabinet paper put together in the Minister's name. So, and it's comes, this obviously predates the amendment paper because the decisions from this Cabinet paper informed the drafting of the amendment paper by PCO. So I'll just reference the piece I'm particularly interested in. So 19A 4B. So essentially what this part, my understanding is, allows is those ringnet fishers who have been fishing within Kawo Bay High Protection Area and Rangitoto and Motutapu High Protection Area. If you go back and look at 19A2, A and B, they will be able to seek an authorisation from the Director General in order to be able to continue operating ringnet fishing in those two high protection areas. My specific question is why and what advice did the Minister receive and why did he agree to include these two high protection areas, where, not just where they were fishing, but specifically where they can continue to fish using this method of fishing? Why did he make that decision? What advice did he receive on that decision, and what other options were looked at? And the reason I raise this is that in his own Cabinet paper with his own name on it, this is what he stated on page 9 of the Cabinet paper, looking at ringnet fishing in 2 HPAs. It says, based on the nature and current distribution of ringnet fishing activities in the Gulf, it is likely that ringnet fishing activity that usually occurs within these HBAs could be relocated elsewhere in the Gulf with minimal impact to the fishers. So the point the Minister has been trying to make in the public domain is that this is important for this practice to continue providing fish to communities. What his own paper says is that those fishes could be relocated to other parts of the Gulf, not the 2 HPAs that are listed in the legislation that are required to be considered for the purpose of where those fishes have been fishing and where they could receive an authorisation to continue fishing. So what advice did he receive? Did he receive advice saying, here are some alternative areas where they could be allowed to continue fishing that are outside of the areas contained within the legislation? What advice did he receive? Why did he proceed with this particular amendment given his own paper? And this isn't advice he received, this is a paper in his name, signed by the Honourable Tama Potaka, Minister of Conservation. His language, his words state quite clearly that the work of those fishes could be relocated elsewhere with minimal impact. So why? Why has he proceeded with this? What advice has he had about alternatives? And I want some specific answers, and I will come back to it, because again, I have not been able to ask these questions of the Minister or of officials at Select Committee. Thank you, Madam Chair.
Madam Chair.
Scott Willis. Steve Abel, sorry.
Thank you so much.
Sorry.
Thank you so much. He has a little more hair than me.
He does.
But
indeed.
not on his face. Thank you, Madam Chair. I really appreciate that. I'm also speaking to section part 2, obviously, and it goes to the question of the purpose of high protection areas, clause 16. For context, I think, Madam Chair, it's useful for us to understand why we have high protection areas. It is because if you exclude extractive activities, if you don't take out fish, if you don't dump waste, if you don't dredge, if you don't mine, if you don't destroy the benthic environment, then that area recuperates, it recovers, the fish species increase, and you get what's called the halo effect, which is the areas outside of that marine protected area get the spillover benefits of a recovered ecology. There's very good evidence that what this amendment does by allowing ringnet fishing is very good evidence of multiple studies of how marine protected areas function, that where you allow extraction or fishing, you seriously diminish the ability of the marine protected area to fulfill its purpose, which is to allow that area to fully recover in an ecologically healthy way. So I want to put it to the Minister. In the purpose of high protection areas, because I do not believe he has answered this, the purpose of high protection areas is to protect and enhance Indigenous biodiversity within the high protection areas, and if that biodiversity is degraded, restore it. We know the biodiversity is degraded. It's unquestioned that it is degraded. Ringnet fishing. People at home might wonder what the heck ringnet fishing is. It's what your grandpa might have called a gill net. It's where you have floats at the top and weights at the bottom, and if you hang it in the water, it will catch anything that comes into it. Stingrays, fish, dolphins, you name it. Whatever hits that net gets caught. They used to be called, you could call it a set net. They are highly, if they're used like that, they are a set net. They can be highly destructive. They are indiscriminate killers. If you drop it off the back of a small boat in a specific manner, you might use it to catch kahawai or mullet. Much less destructive than if you use it as a set net. So this type of fishing, and I would like the Minister to respond to this, is completely contradictory to the fundamental purpose in clause 16. How does the Minister justify allowing ringnet fishing to be consistent with that purpose? The other thing that seems striking to us, this is the second point, Minister, is the timeline around the decision that was made to make these amendments. I have the entire timeline here, and I will spare you going through it. A number of meetings that Minister Jones and Minister Pōtaka, starting with a bilateral meeting on the 17th of September at 8:30 p.m, meetings with Department of Conservation and bilateral with Goldsmith and Conservation on September 19, meetings with Jones and MPI on the 23rd of September, a cabinet meeting. I'm not going to run through all of it, but Jones met the High Seas Fishing Group on the 23rd of September. Pōtaka met with Department of Conservation on the 23rd, met with MPI on the 23rd,
Good call.
and then we get to a moment where there's a cabinet note that says on the 26th of September, the Minister for Oceans and Fisheries has also raised potential amendments raised with him by the seafood industry. And you have met and discussed these with him and received further advice. You have indicated that you do not wish to progress any further amendments. That was a note that the Minister in the Cabinet paper did not wish to advance amendments. And Madam Chair, the reason I'm asking this is I want to understand and respond to the public's concern and our concern that the changes in this paper, the amendments, are the direct result of lobbying by the fishing industry. Madam Chair.
Members' time
Madam Chair.
has expired.
Madam Chair.
I call the Honourable Tama Pōtaka.
Look, I think all members, including those opposite, present or absent, understand that the Hauraki marine protection intentions that are well articulated in this Act are a compromise. In the event that members opposite wanted to enhance to the greatest optimisation the biodiversity, we would have had marine reserves all over these spaces.
Point of order. Apologies, but look, we are just having difficulty hearing the Minister. So if perhaps the Minister could be closer to his microphone, or those operating could turn up the audio. It's just difficult to hear his answers. Thank you, Madam Chair.
Okay, I'll just lean in a bit, or maybe I'll speak louder. The members opposite know that this legislation is a compromise between a number of communities. In the event you wanted to maximise the biodiversity and minimise the target species that have been taken out of the ocean, previous administrations would have promoted the whole of the Hauraki Gulf as a marine reserve. However, that was not the choice that was made, and there have been ongoing engagements and compromises around a number of issues well set out in this legislation being proposed today. Now, there's been a range of tautology and speculation in relation to the ringnet fishing, and for the 16th time today, I will respond that ultimately there is a balancing and a compromise that is undertaken with the legislation. We all know that over many years, the previous government sought to enhance marine protection based off work that was done through sea change under the John Key, Bill English-led national government, and we got to a position where now we have a compromise solution that this coalition government is very convinced and persuaded we can turn into legislation. The incomplete nature of our legislation is not giving anyone any satisfaction, and that's why we have got to the space that we're in, where we're going to progress the bill and hopefully in the next week or two turn it into legislation. The biodiversity impacts that have caused so much polarisation by some members of our parliamentary community have actually been very well minimised by the conditions that are now upon the ringnet provision. There was advice earlier on, which has been referred to, that ringnet fishing might not be a great idea in terms of achieving the biodiversity outcomes and other outcomes in the legislation. But you know that this legislation is a compromise between a wide variety of parties, and that's why we've ended up in a space where we are convinced that we can get this legislation through with the relevant numbers in Parliament. However, things aren't perfect in this world. As you know, sometimes people get called the wrong name in this house.
Thank you for that.
Things aren't perfect, but what we can do is get to an acceptable solution for some of the issues that we are dealing with. I'm advised, again, that the DOC advice was to limit ringnet fishing to the 2 high protection areas, which this bill does. This is what this bill does. It does restrict it to 2 areas. And we can speculate and get a pen and draw the areas that we want it to be in, as some members want us to do. But these were the 2 that were chosen, and these are the 2 that are going to progress. How does the Minister justify ringnet fishing in HPAs? It is limited. Positive biodiversity outcomes are expected as a result of this bill.
Members, I'm sorry, but the time has come to report progress. We'll just wait.
The House is resumed.
Madam Speaker, the committee has considered the Resource Management Consenting and Other System Changes Amendment Bill and reports it with amendment. The committee has also further considered the Local Government Water Services Bill and reports it with amendment, and divided into the following bills: the Local Government Water Services Bill, Local Government Water Services Repeals and Amendments Bill. The committee has also considered the Hauraki Gulf, Tīkapa, Moana Marine Protection Bill and reports that it has made progress on the bill. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The Resource Management Consenting and Other System Changes Amendment Bill, the Local Government Water Services Bill and the Local Government Water Services Repeals and Amendments Bill are set down for 3rd reading next sitting day, and the Hauraki Gulf Tīkapa Moana Marine Protection Bill is set down for further consideration in committee next sitting day. The House will adjourn until 2 p.m. today.